Number 17, my lord. 17. In this particular case, I have filed today the amendment petition, my lord. Amendment petition, I have filed today, amendment petition, so that let this matter may come in next week along with the amendment petition, my lord.
Mr. Bhatti, the learned counsel appearing on behalf of the petitioner submits that an application seeking amendment of the writ petition has been filed. And as such, the instant writ petition be adjourned. Accordingly, the writ petitions, the writ petition stands adjourned to be listed along with the interlocutory application.
My lord, item number 63 and 64, my lord. Maybe item number 63 and 64. Well, maybe taken at 2 p.m., my lord. There is some urgency, the disconnection of electricity, my lord. Lastly, listed on.
Oh, all these matters.
Yes, my lord.
You see. Don't worry, we'll take it. You filed affidavits.
May please also.
Well, in these matters, my lord, yesterday we have filed affidavits in the two cases. Along with the affidavits, we have also filed one interlocutory application. I may be allowed to call for all the pleadings, my lord. I'm so deeply obliged.
May please also. In item number 58, my lord, I have filed an interlocutory application for impleading of the private respondent, my lord. This matter is fixed at 2 p.m., my lord. I hope, my lord, in the meantime, that number will be registered, my lord. Your lordship may call for the record of the item.
No, then I will adjourn this matter.
But I have not taken the consent of the petitioner today. Let the
Then
matter
don't-
come. In the meantime, we'll
When the
file.
matter reaches, then you make the submission.
My lord,
Who are you?
I am for the private respondent,
We'll see when the matter reaches.
my lord.
Yeah, please. I
Obliged.
recommend item number 24, Lordship, with the consent of the other party, Lordship. Actually, Lordship, I have not filed a affidavit, Lordship. And actually, as some required document I have not obtained.
24.
Yes, Lordship. Kindly adjourn the matter for today.
You are for the?
Petitioner, Lordship.
The counsel appearing on behalf of the petitioner expresses difficulty and accordingly matters stands adjourned to be listed on 12th of October.
May it please, your lordship. The lordship, in item number 3, we have filed 2 additional affidavit yesterday. That is bringing on record the unconditional apology as well as the
That one. Yes.
as well as we have released the attachment. Obliged, lord.
May it please your lordship. Lordship, I beg to mention item number 35, lordship. The conducting counsel, Mr. F.A. Borvia, he is unable to attend the court today due to waterlogging.
Who?
The conducting counsel, Mr. F.A. Borvia. Lordship, kindly on Monday, lordship.
Item number?
35.
What is the urgency?
Lordship, if not today, then lordship any other day, lordship.
Any stay?
Lordship?
Any stay?
No, lordship.
At the request of the learned counsel appearing on behalf of the petitioner, matter stands adjourned to be listed on 14th of October.
Yes, lordship.
So, Lord,
Yes, what is this?
lordship, in this matter, lordship has directed the district commissioner Kachar to appear through VC, my lord. Lord, in fact, what I have find in this case, my lord, there is a miscommunication from our office, my lord. The communication which we have sent to the district commissioner, it shows that the matter is coming on 14th of September. So you provide us the instructions by then. Because of that miscommunication, the 24/8 was not intimated to the DC, my lord. And in fact, some instructions we have received in the meantime. We'll file the affidavit. Lordship may kindly grant us some time, my lord. Otherwise, there are some developments, my lord, I have gone through.
But your counsel only said on the last occasion
That's
that
true.
he had
That's true.
duly informed.
That's true. That's true. That's true. It was a
miscommunication on my side, my lord.
And we impose a cost upon you for asking the deputy commissioner out there.
No, my lord, they.
No,
why-
you made a
Let me
submission.
explain, my lord.
You made a submission to that effect. Impose a cost upon you of 10,000.
No, my lord, let me make my submission.
No, nothing doing. You made a categorical submission because of that. You said to me that on the last occasion that we have communicated to the
Yes, my lord.
deputy commissioner and there has been no instructions.
Yes, my lord. But my lord, while dictating the order, my lord, after that I came to know that in my notice it has been said written as 14-9, my lord.
So therefore,
It's a mistake on my part, my
so
lord. While
therefore, I am not imposing upon the DC. I am imposing upon you. Because of that, I am imposing upon you, not to the DC. Because of the miscommunication.
in that case, I seek a sincere apology, my lord.
No apology. Don't make this. You see, the DC is otherwise a busy person. There has been an undertaking given by the chief secretary to the effect that the deputy commissioners the district commissioners shall always aid in the process of the court. And and I was under the impression that in spite of the affidavit which has been filed by the chief secretary and the DCs, the concerned DCs giving an undertaking to the chief secretaries, then also the DCs are not here abiding by the undertaking given to the chief secretaries.
My lord, sometimes
You made a categorical submission on the last.
sometimes bona fide mistakes do happen, my
Not,
lord.
you see, you have to be very careful. You can't. This is not a this is not a court of joke. You cannot be doing this.
Okay, my lord.
The instant writ petition is listed today, seeking the presence of the district commissioner Kachar to the video conferencing link on account of a categorical submission made before this court on 24/8/2026. That in spite of due information, the district commissioner Kachar had not provided any instructions. Today, when the matter is listed, Mr. So-and-so, the district commissioner Kachar is present. It has also been informed to this court that a communication which was sent by Mr. N. Das, the learned government advocate, to the district commissioner Kachar, mentioned that the next date fixed was on 14/9/2026 and not 24/8/2026. Under such circumstances, it is the opinion of this court that there has been no error on the part of the district commissioner Kachar in not making available the instruction as on 24/8/2026. This court dispenses with the presence of the district commissioner Kachar. This court further inquired with Mr. N. Das, the learned counsel, who made that submission, more particularly taking into account that when there is an appearance of an official of the government, the official has to leave other duties to attend to this court. Such irresponsible actions on the part of the council has not only led to the district commissioner Kachar to attend to this court and thereby leaving his other duties, but have also put the majesty of this court into disrepute. Because under such circumstances, it is the opinion of this court that the learned counsel, Mr. Endas, the learned government advocate Endas, should be reprimanded. And accordingly, his conduct stands reprimanded. Mr. D. Nath, the learned counsel, learned senior government advocate, apprises this court that the instructions have been received and the affidavit would be filed on the by 9th of September.
Look, can I prefer 14th, Malad? 2-3 days, Malad.
Why?
But some clarifications I require. I have received the instructions, but some
This is a matter of 2018.
18, Malad. Other.
Okay.
It's true. On 14, Malad.
Yes, Mr. District Commissioner. Why you have not till date disposed of that application? Can you hear me?
Sir, yes, sir. May I come in, sir?
Yes. Why you have not disposed of the application which has been filed by the petitioners?
Sir, I assume charge as District Commissioner Kachar on 30/6/2026. The instruction letter was received in the district office on 1/8/2026 and communicated that the matter stood fixed on 14/9/2026.
No, that I understand.
Sir.
That I've already passed the order on that. My question is, there was a representations given to your office on 28/10/2017. We are 9 years down the line. Why your office till date have not taken any action? Because there is an interim order operating. The interim order was passed as far back as on in the year 2018 itself, 6/4/2018. So why there is no action on the part of the office of the Deputy Commissioner?
Malad,
Sir, as soon as it was communicated to me, sir, we held a meeting with the state authorities on 21/8/2026 to settle on the comments. Sir, the matter has been taken up earlier as well, and right now also, sir, I am following it up, and we will fight the affidavit in opposition, sir, as per the timeline that been
File your
suggested by
affidavit
the
by
Honorable Court.
Lord, There,
File your affidavit.
there are developments, my lord. Respondent number 11, who is a party here, they have filed subsequent repetitions. There are orders and
Whatever may be.
Lordship.
This is a matter of 2018.
Correct.
Or if you are district commissioner or your government wants the matters to be just stagnating out here, it's okay.
No.
Then there is no importance. Hey,
We'll file.
whenever Mr. D. Nath mentions a matter for urgency, no urgency.
No, my
I'm
lord.
making it very clear.
we'll-
Don't
we'll-
come up with this type of excuses before me.
No, my lord, there are developments.
When,
That is what I am
whatever it
apprising.
may be, this is a matter of
We'll file.
2018. If
Definitely,
a
Malad.
petitioner is not going to get a dispute resolved in 8 years, then I think it is not good for the petitioner to approach the court. People are losing the faith in the judiciary because of the officials not taking the steps properly.
No, my lord, I'm not on that, my lord. Absolutely, my lord. There are developments I have received. We'll file
Whatever
it.
may be, the developments have been given. Why all these while the map period, everybody has been sleeping? The
We'll file.
order was passed on 27/7/2026.
No problem.
Wherein I have asked you to provide the instructions on that day.
Lordship.
Then also I fixed it on 24/8. Okay, let the government council have made that mistake. But that doesn't mean that you are going to sleep tight till this.
No, definitely not. Definitely.
We'll have it next week,
Lordship.
not on 9th. We'll have it
Lordship.
next week.
Lordship.
Please the matter again on 2nd of September 2026, on which date the DC Kachar shall provide necessary instructions as to why the representation dated so and so have not been disposed of.
Second, my lord, first is the holiday. My lord. Kindly,
Sir,
kindly.
Second, Because of your conduct. I have fixed a particular date. Why have you said that not possible?
Lordship, we'll do that. We'll do that.
9th
We'll do that. Lordship.
is the matter on 9th. So the instructions be placed before this court on the next date without fail.
Lordship. Highly observed, Lordship.
Wait, please.
Yes, your case has to be finished up today.
Yes, my lord.
Unnecessary.
May I submit, my lord?
Is the acquisition in your land?
It is on my land. Petitioner, the acquisition is on my land, my lord.
Have you received the notice under Form 3?
No, form 1 and 2, we have not received, which was pertaining to requisition process, my lord. That is my grievance, one-fold grievance. And after that, under 3, my lord, the process of acquisition, they have not yet started, my lord. It is yet start, my lord.
No, no. Have they started the requisition process or not?
That has already been over, my lord.
They have requisitioned.
They have, my lord, completed the requisition process, but the acquisition process is yet to begin, my lord.
My question is, has the requisition process completed?
Completed because they have registered a case called LA case number such and such of 2000.
That is a different thing. LA case number registration is different
My lord.
from requisition. Has the requisition notice been given to you? But then there is no requisition.
My lord, they said that they have given, my lord, in the instructions,
Ah.
but I have not received, my lord. That is my case, my lord. In the
What
instructions, if your lordship comes-
what do they say in the affidavit?
Yes, my lord. If a lordship comes to their first instruction, my lord. That is instruction dated 21/02/2026, my lord. With reference to the subject cited above and later under reference, I have the honor to inform you that the proposed location for the foot-over bridge between Bhagadatta 1 and Bhagadatta 2 has been fixed by keeping in view the land tag number so and so in present case, but that can be skipped, my lord.
And you are the owner of which land?
I'm the owner of, my lord, 1066, my lord, tag number.
So from you, 4 letters would be taken.
Polish will, my lord, they will acquire.
May I please? I have received the instructions in respect of LA case number 27/2025. This is to inform you that the land measuring 4 letters covered by DAG number 1066 of Patta number 131 of Village Sorumotori under Moja Beldola has already been requisitioned under section 3(1) of the Assam Land 1964 by order number LA so and so so and so. The acquisition process has been put on hold due to filing of the present writ petition. And we have
So
been,
that means possession taken.
Virtually, but I'm still in occupation, my lord, because they have not started the project.
Have you taken the possession?
Lordship, regarding that, Lordship, I have no instructions, but
no.
we have been directed to.
No, section 4 says that once you requisition, you will take the possession. But if you have not
Otherwise-
taken the possession, means you have not, the entire aspect of requisition has become meaningless. You see, why do you requisition? Requisition is an urgency.
Yes,
Now, as of now, you have not, acquisition is, I'm not on that, but requisition, once you do it, you have to take possession. You have not taken the possession.
Lordship, that is but because of most probably pendency of this writ petition.
There's no stay.
No, my lord.
No stay, Lordship,
Then-
but even then, Lordship, when there is a case is going on before this honorable court, normally.
We shall take it as a statement
no,
that
no, Lordship,
whenever a case is pending, you don't take any action.
No, Lordship, that is.
Then
not-
don't make that statement before this court.
But that is the instruction, Lordship, and we have been directed regarding this ingress and egress, whether is there any. But that report here is also we have received from the Dispersal Circle Office that there is no such will
No,
be
the
affected.
thing is, if you have not taken the possession till date, This was done long time back,
Lordship. 25.
25. So therefore, who is there for the PWD? PWD has no business out there. Requisition will be done by you.
Yes, Lordship. But that instructions they have placed before your Lordship on the earlier date, Lordship, that is marked as, your Lordship has marked it. And I have also received that instructions pursuant to direction passed by His Honorable Court. The joint verification was conducted, joint survey.
Now then, if it is required for your, if it is required under the section 3 or section of the act that you can exercise that power, then in that case, you do it. Take into consideration if he has a loss tomorrow, that because of that he cannot go for a construction of a big storied building, then you pay your
No,
compensation.
their main grievance is that regarding ingress and egress. That is pursuant to the direction passed by this Honorable Court, a joint survey was conducted, and my report, our report is that it is found that the petitioner land, the petitioner's ingress and egress will not be affected due to the construction of the proposed footbridge.
So then can we pass an order that no, that you can go ahead with your acquisition or requisition without disturbing the
Yes,
petitioner's
Lordship.
ingress?
On the basis I am placing it, your Lordship.
Are you sure? He
Lordship.
wants that only.
Yes, Lordship.
He wants one there. But do you understand what you are saying? You are giving 16 feet
16.50 feet.
and
wide.
he needs how much?
19 feet.
Pursuant to the fire brigade, Lordship. On that
So
day.
you give him 19, keeping 19 feet alone?
No, they have stated 16.50.
Give us as an undertaking that you will keep 19 feet, the petitioner has no problem.
Yes, my lord.
No, that is not here. That is
So
16.50
therefore,
feet.
don't make that submission. You are making the submission as regards ingress and egress. His ingress and egress he's asking for 19 feet. And the moment I pass that order, you cannot have less than 19 feet. And then it may not be viable.
মানে স্যার এই এম্বুলেন্সৰ পৰা ফায়াৰ ব্ৰিগেড যাবলৈ লাগে মোৰ ঘৰে হয়।
But here, Lordship, 16.5 feet.
The present petition has been filed by the petitioner challenging the initiation of an LA case number 27/2025, whereby the respondent authorities are proposing to acquisition 4 acres of the land belonging to the petitioners, covered by DAG number 1066 of KP Patra number 131 of village Horumotoria under Dispur Revenue Circle, Kamrup Metro at Gauhati, for construction of proposed foot overbridge between Bhagadatta 1 and Bhagadatta 2 on the GS Road. Pursuant to directions passed by this court in the order dated 27/2/2026, there was a physical verification carried out. And it is mentioned that the petitioner's ingress and egress to the extent of 16.5 feet. 16.5, na?
50, my lord. 16.50.
May I place it, Lordship? Lordship can.
Okay, I have it. 16.50.
50.
5 feet. 5 feet. Of the mentioning that the petitioner, that the petitioner would have a ingress and egress after the acquisition is carried out to the extent of 16.5 feet to the petitioner's land. Mr. H. Puragoy, the learned counsel appearing on behalf of the petitioner, submitted that the petitioner intends to give the said land for construction of multi-storied building, and in terms with the requirement as set out by the fire for obtaining the NOC from the fire department, there has to be at least an at least a passage of 19.5 feet.
19 feet, which is equivalent to about 6 meters as per the
19 feet, which is equivalent to 6 meters to the petitioner's land.
Malot.
Full stop. The Mr. H. Sharma, the learned counsel appearing on behalf of the circle officer, appearing on behalf of the deputy commissioner, district commissioner, Kamrup Metro, submits that he would obtain necessary instruction as to whether it is permissible to whether upon acquisition the petitioner can still have an access to have a passage of 19 feet, which is equivalent to 6 meters to the petitioner's land. An affidavit be filed on behalf of the district commissioner, Kamrup Metro, in that regard. List this matter when you don't have any urgency. The matter has been going on from such a year. 2nd of November 2026.
I'm highly obliged. Malot.
Mr. Ahmed, upon writing the judgment out there, I held that you are liable to be registered. But I have set aside and quashed the seizure.
Lordship, here we are already some money has been sanctioned, Lordship.
Money sanction?
Lordship, it is in the final stage of payment, Lord. I have also given a copy to my friend, Lord.
FOC?
FOC. It is FS, Lordship. FOC will be issued by the Finance Department, Lordship.
Mr. N. Upadhyay, appearing on behalf of the respondent, submits that the financial sanction to the amount receivable by the petitioner to the tune of rupees
44 lakhs, 43,000,
44 lakhs 43,000
535.
535 have already been issued immediately upon receiving the financial FOC. The petitioner would be disbursed the said amount. The financial sanction is kept on record and marked with the letter X. Accordingly, list this matter again on 2nd of November 2026. In the meantime, the payment immediately upon receipt of the financial FOC, the petitioner be disbursed the amount and
Lordship.
update be placed before this court on the
Obliged.
next day.
May it please, your lordship. Two additional affidavit has been filed, both by respondent number 1 and 2, your lordship.
Stop. This is an application filed by the petitioner alleging willful and deliberate violation of the order dated 25/11/2024, passed in WPC number 6187/2024. Whereby a direction was issued to the respondents to proceed in the matter in respect of the notice of demand dated so and so issued to the petitioner, but no final order should be passed without the leave of the court. Irrespective of the said order, an order of attachment of the immovable property was made on 31/12/2024. It is on the basis thereof the present contempt application has been filed. Pusto. Today, pursuant to the order passed by this court on 25/8/2026, an affidavit has been filed by the contender number 2, tendering unconditional apology for misreading the order dated 25/11/2024 passed in WPC number 6187/2024 and attaching the Asitpur Tea Estate without the leave of the court. It is also mentioned that the order of attachment dated 31/12/2024 have been withdrawn by the notice of withdrawal dated 26/8/2026. Taking into account the affidavit filed by the respondent number 2, this court duly accepts the apology tendered and accordingly drops the present contempt proceedings.
Respondent number 1 and
My
2.
lord, so far as I may be allowed, my
Yes.
lord, 3 months' time, my lord, I
No, no,
pay
no.
all the dues. Because these are their habitual conduct, my lord. They
Lordship,
withdraw the
wait.
cases. Yes.
Respondent one number 1 and 2 both has filed an affidavit for apology. And-
Affidavits filed,
Yes,
the main petitions,
Your Lordship, there is a development. I just given a
this matters again on.
the papers have been handed over. We have withdrawn the demand notice also that I have just handed over this
Why have you withdrawn the demand notice?
because from 24 there has been not being payment. So those amount also will include in the fresh demand notice now. Right from after getting
This
the
is a different thing. That has to be done with the year.
Hmm.
We do one thing as regards the interim order is there.
Right.
We modify or tweak the interim order to that effect. That not to do anything will continue, not to without the leave of the court. But during this period, the mortgage property should not be encumbered or transferred.
My lord, the dues that dues I'll be paying, my lord, by selling a portion of the land. To that effect, I have filed an affidavit. Your lordship may kindly see the affidavit that I have filed. Lordship in WPC number 153925, my lord. Page number.
Isn't that mortgage to them?
While they were attaching my property, I could not sell them. No customer were coming.
But I'm now asking you, is that property mortgage to them or not?
No, my lord.
Then there is no problem.
Yes,
It's not, it is only the attached property.
yes, my lord.
So
Because
the
of
property
attachment,
which is mortgage to them, you cannot transfer.
that is there.
They can only attach only the mortgage property.
yes,
No, you can attach which property?
the entire tea estate.
No, how
The
can, how the
entire
demand
case-
of rupees 1
Lordship,
crore, they can enter, that
he
is
is
the
telling-
illegality they have done deliberately.
Mhm.
My lord, they have entered my 156 bighas of land, my lord, disproportionate, and the division bench has come to a finding. We have challenged the order of the single
Mhm.
bench, my lord.
Lordship, what is
Justice Sumitra Sikha allowed us to file an affidavit as to how we can pay the amount, my lord. Accordingly, we have filed.
So what is the amount?
amount is 1 crore something around 12 lakhs, 1 crore 12 lakhs. Lordship, he is
Lordship,
telling we have not a problem, but there is an issue that is not concerned with us, but with the other authorities. The tea unit as such is registered with the tea board, and also the Labor Plantation Act. Now, if he sells a portion of it, he'll have to get permission from the tea board also the revenue authorities. Because now that will become and that sale portion also has to be used as a tea garden. Otherwise, the Ceiling Act will come into operation. So and the labors will be retained by him or it will be handed over to the new owner.
Who is the
Then-
owner?
I am the owner. my lord.
No, if he sells of a portion of the tea
My
garden,
land, I am not able to
that
sell.
land
This
cannot be used for any other purpose. It has
My
to be
lord,
used for the tea garden.
Whole
East.
nexus is going on, my
plantation.
lord, to.
That is a different thing. Whether it is sold as a tea garden or not. You see, for the purpose of selling a tea garden, they cannot get a permission from the DC. They have to get it from the government.
Here in Dispur.
Now that it is free from attachment, I will get the permission, my lord.
Huh?
I'll be applying for the permission.
It's okay. Now the question is, what is the dues payable to you?
1 crore around 12 lakhs.
Now 1 crore, this is PF.
It is their claim. I have disputed, my lord. Whatever.
And also the current amount which he has not paid from 2024.
That all I'll be giving whatever is due to them. That is what I am saying in affidavit. Only thing is that I need 3 months, 4 months of time so that I can get the money and pay him, my lord. But they are repeatedly attaching, trying to grab the whole land, my lord, and coming in contact with my employees. Without my authorization, they have even given the Jimma. Can your lordship believe that?
Jimma to?
Jimma to one Gogoi, Mr.
No, no,
Mr. Gogoi.
He is
Yes, my
operating
lord.
the garden.
That is in the
We
contact.
have
petition I
attached it,
mentioned.
his signature, he is operating, he is selling
My
the
lord,
lease.
without authorization, they are doing behind my back, my lord.
We
They are
have
not
not-
allowing me to run the garden, my lord. They have destroyed, plugged everything, committing theft, everything, my lord. Laborers are being instigated, my lord, so that I get unstable.
No, all are understood.
Yes.
My question is now, how are you going to pay?
I'll pay, my lord. Lordship, I have filed affidavit. May kindly, lordship, page 48, my lord. WPC 1539, that is item 5, my lord. That item 5, 153925. There I have filed affidavit, my lord.
Because you are concerned with the money.
We are
Yes,
concerned with the money.
Lordship first may, yes.
How he gets the money,
Yeah,
that is
that
his
is my
matter.
lookout.
He tomorrow does whatever it is, you want the money.
Yes.
Yes. Lordship may kindly see the order dated 2/9/4/25, passed in WPC number 15399, Lord.
Where is your affidavit?
My lord, affidavit is page 48, my lord. In WPC 1539. As per the order of this honorable court, as to how will I pay, my lord, in paragraph, page 50, lordship will find at paragraph 3, my lord. That the petitioner begs to state that he intends to sell a portion of the plot of land, that is 200 bighas in the eastern side, out of total area of his land measuring 1569 bighas of tea plantation, to prospective buyers and pay the legitimate period within the period of 3 months, subject to the condition that the order of attachment, this so and so which they have withdrawn, is withdrawn by the respondent, more particularly the responsible recovery officer. So this is my contention, my lord. Now what they are doing, they are not for 2 years, lordship can imagine, they have made me physically, mentally such a harassment, my lord. I could not even survive with my family.
2 years has not happened because the order of
Whatever.
attachment was passed, the stay was granted. The order of attachment was passed on when? 31/12/2020?
24.
24 December last, so
Oh,
practically 1 year.
As of now also
what?
2 years have not come.
One
Be
and-
that as it may. You do one thing, you give an updated, because updated demand what
Right.
it is, file an affidavit to that effect. As the order of attachment is removed today.
Yes.
Now, you, first of all, you selling this 200 bighas is impossible.
That is my lord, I'll pay his amount within the whatever 3-4 months, my lord. I'll pay out that.
We have it next week. You, next week or next to next week.
We'll file an update.
Would it be possible on your part to get the details as to how much amount it is by next week?
Yes. We'll get-
Because next week we are only having 2 days, working days, two working days. You can give it by third,
Yes.
list these matters on third.
In the meantime, my lord, I will apply for permission, my lord. So that
I'm not concerned how you do it.
yes, ma'am. That
List
I
the
will.
matter on third.
And proceed.
On which state Mr. R. Sharma, the learned counsel appearing on behalf of the Provident Fund authorities shall give an updated status to the amount payable by the petitioner. This court further takes note of the interim order passed by the learned court bench dated
This address to me only.
(25/11/2024), whereby it was mentioned that the department shall proceed in the matter in respect of the notice of demand dated 12/11/2024 issued to the petitioner, but no final order shall be passed without the leave of the court. The said interim order shall continue further with a slight modification to the effect that if the petitioner cannot transfer the mortgage properties. This is not a mortgage, you are not a bank.
mortgage.
We have first charge by law.
It is not mortgage.
The petitioner shall not What does this tea garden have?
Yes, my lord.
What does the tea garden have?
Only garden, my lord, without any factory, my lord. Garden
And no
And-
factory.
and no factory, my lord.
Shall not transfer or alienate the tea garden without the leave of the court. However, the petitioner can enter into negotiation with prospective buyers for the sale of the garden or part thereof, and thereupon seek appropriate leave from the court. Both of you are protected.
That means I can enter into agreement for sale, my lord.
Yes, I say that you can enter into negotiate or redo it, but we
I'll take the leave.
cannot only transfer.
Deeply obliged.
Content of-
Highly obliged.
My lord, this case has been listed on my prayer, my lord. And by the order dated 29/1/2026, we are short of the time to file the affidavit, my lord. So that, my lord, this matter may kindly be listed in next week for admission, my lord.
What is there to Ria?
My lord,
Demand comes show cause notice. Is there a
so
stay?
for notice and thereafter, my lord, the appeal was filed at the initial stage. The appeal was rejected by the
Order
learned.
has been passed or show cause notice has been passed?
So goes notice and as well as the appeal.
Huh?
My lord, appeal
Order has
against the
been
appeal.
passed, thereafter they preferred appeal, appeal has been rejected.
And after that, I came
After
before
that,
this.
They have
After that, he has come before this
Lordships.
court challenging 9.
lordships, 9.
And this honorable court allowed me 1 month time to deposit pre-deposit, my lord.
No, no, no.
That
this
deposit
type
was
of
made
case.
only,
Where is that
by
appeal? Where
eight-
is the order passed?
that order of this honorable court, my lord.
No.
Appellate
that
order is at
Appellate
page
order-
80.
Huh?
Page 80, Annexure K.
No, 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 no. The first order passed.
Order in original, Your Honor.
First, who are you? Who are you? I don't recognize you. You go. Non-APS. I can't hear you. Have you been appointed? Have you been mentioned anywhere that you can assist Mr. Kyle?
Mr. Kayal is on legs at.
Whatever may be, you make that submission, because otherwise, if you on your submission, if I pass an order, then it will create a havoc.
Apologize, Your Honor.
Yeah. You have no business.
My lord, let this matter be listed on Tuesday for admission, my lord.
What is your challenge?
My lord, I have challenged the appellate order, my lord.
Why?
That your order,
Why?
your lordship will find at page.
Why have you challenged the appellate order?
Appellate because that was rejected
Huh?
at page 80, my lord. And that was and 11 page is 95, my lord.
Now, why are you challenging the appellate order?
Appellate order, my lord, because I was not given the opportunity.
You have
Then
filed
it
an
was,
appeal. Don't come up with all these
disposed of.
things.
My lord, your lordship may come to page 95.
Page?
95. That is the order.
Yes.
In view of the above, I reject the appeal and upheld the impugned order that such and such. Consider non-compliance with the mandatory provisions contains 70 and non-timely compliance of the order of the Gauhati High Court dated such and such without going into me.
So what was the High Court's order?
Order your lordship will find at page. Just a minute. At page 74, my lord. '74, my lord. And the operative part is at page 78.
So you deposited the statutory deposit.
Yes, I made, but I made it late, my lord, by 8 days. By 8 days, I did not make it within the 30 days period as allowed by
Where?
the honorable court. And this was paid,
Now,
and
where
that
is it
has been
mentioned?
reflected, my lord, in the order
The
itself.
appellant has submitted a letter for extension order for making the pre-deposit on Iman, which is the fair gain of the extension granted up to Iman. And it was not possible to communicate the appellant about the acceptance or anything. Hence, before taking any decision in the matter, appellant was granted a personal hearing in compliance with IA. In the meantime, the appellant has submitted a letter enclosing therein a challan. Do not find this. The appellant and were available to the IA. Okay. So this is the only thing.
This is only the
We,
case.
we do one thing, set aside this, asking the appellate authority to reconsider.
Yes.
Third, Mr. O.P. Bhatti, the learned counsel, appearing on behalf of the petitioner. None has appeared on behalf of the respondents on call. The present petition has been filed, assailing the order dated 16/9/2025. 16/9.
Yes.
16/9/2025, passed by the Additional Commissioner Appeals. CGST, Central Excise and Customs, thereby dismissing the appeal on the ground that the petitioner failed to submit the pre-deposit on 12/6/2025, and the petitioner submitted the same on 26/2025. This court have also taken note of the reason as to why the learned, why the appellate authority did not decide the appeal on merits, rather dismissed it at the threshold. From a very perusal of the impugn order, it appears from a perusal of the materials on record, it is seen that the petitioner had approached this court by challenging the order in original dated 2012-2023. Have challenged the order dated 31/1/2025 passed by the appellate authority in WPC number 2374/2025. On the ground that the said appeal was dismissed on not making the pre-deposit. The learned coordinate bench of this court rejected the said contention of the petitioner and granted a period of 30 days from the date of the said order to deposit the statutory deposit, and thereupon the appellate authority shall decide the appeal on merits. Mr. Bhatti, I can't do anything. The last line of that order is very dangerous. I cannot sit on this order, no?
That is there, my lord.
I
Only
can't help you.
8 days delay, my lord.
Can't help you because it is made clear that if the petitioner does not appear on the said date and does not make a pre-deposit, the order, because the order that has been set aside shall revive.
Shall be, my lord. That is there, my lord.
The
but
single bench, I cannot sit aside that because this is the direction.
My lord, the further only 8 days delay is there.
I can't help you. With this, I can't help you. You can seek a review. That is what I can give you the liberty. That is the only way out. But otherwise, I dismiss it.
All right.
And after review, you can go there. That is the only way.
Yes.
It was further directed by the learned coordinate bench that if the petitioner did not appear on the said date and does not make a pre-deposit, the order which has been set aside shall revive automatically. Paragraph 12 of the order dated 13/5/2025 being relevant is reproduced hereunder. The period of 30 days elapsed much prior to 26/2025. Under such circumstances, it is the opinion of this court that a liberty which was granted to the petitioner had failed to take benefit of the same. And this court in a separate writ petition cannot sit over the directions passed by the learned coordinate bench in the order dated 13/5/2025 passed in so and so. It is the further observation of this court that in the if this court grants a further extension or directs the appellate authority to accept the pre-deposit, the same would be nullifying the order and the directions passed by the learned coordinate bench in the order dated 30/5/2025 passed in so and so by the learned coordinate bench. Accordingly, this court does not find merit in the writ petition, for which the writ petition stands dismissed. Before parting with the record, this court, however, observes that the dismissal of the instant writ petition shall not preclude or prejudice the petitioner to apply for a review of the order dated 13/5/2025 passed in WPC number so and so, explaining the reasons of the order dated so and so before the coordinate bench.
But
You explain. This is the I can't help
Yeah.
you. But that otherwise, till without that last line, I could have taken it.
But here, not will grant me time to file my affidavit. We are facing difficulty in verifying it because some documents we have sought for, then neither he is giving it nor saying I don't have it.
Huh?
Some verification that documents,
Petitioner not helping you out.
either he gives it or say, no, I don't have it, then we can make a verification finally. That has not been
We
done.
drop the.
I will put it on affidavit, my lord. Let it be after 2 weeks, my lord.
Mr. Asbora, appearing on behalf of the respondent, submits that for compliance of the order passed by the learned coordinate bench dated 16/5/2025, passed in WPC number 3427/2024, there is a requirement of carrying out certain verification. However, in order to verify, the respondents have sought for information from the petitioner, which the petitioner is not providing. So it is the opinion of this court that such aspects be brought on record by filing an affidavit. More particularly, taking into account that this is a contempt jurisdiction. Accordingly, list this matter on 11th of September 2026. The affidavit be filed on or before 9th.
Lord.
Just that
Yes.
small affidavit.
Okay.
May it please, your lordship.
Yes, madam.
Lordship, I'm appearing for the sole respondent, lordship. We have filed our wakalat number today, lordship. I'll pray for some time to file our affidavit, lordship. Although instruction has been received, it is not sufficient. They have not explained as to why it has not been complied, Lordship. So I'll seek for 3 weeks' time, Lordship.
Why haven't you made the payment?
Lordship, that explanation has not been given yet.
Huh?
In our instruction that we have received, they have not explained to us.
No,
So
no, no,
we
no.
would like
I'm
to-
not on that. Here, there is a specific direction passed by this court
Lordship,
that he is entitled to the amount of 9,50,000 as it is admitted by the respondent.
Lordship,
Gave you 6 months. Why haven't you paid that?
Lordship, that's what the instruction is insufficient. So,
Why? 1 year has gone now.
Lordship, they have forwarded us this,
This is a violation.
Lordship.
We then direct the initiate contempt proceedings against. Who is that officer? Joint Director.
Director
Officer.
of this-
Initiate contempt proceedings. against.
A week's time for clarification, Lordship.
Ms. So-and-so, who appears on behalf of the sole respondent, seeks for a week's time to bring on record the stand of the sole respondent as to why the payment as directed by this court in the judgment and order dated 22/8/2025 in WPC number 4170/2024 have not been made to the dispersed to the petitioner. List this matter again on 9th of September 2026. Failure to file the affidavit, this court shall construe to be failure to hear, this court shall pass appropriate directions.
Obliged,
Next time, it is a contempt.
Lordship, obliged.
My lord, I am
What is
appearing
this?
for the writ petitioner, my lord.
Huh?
I am appearing for the writ petitioner, my lord. In my writ petition, my lord, all are official respondents, my lord. I don't know, my lord, how come, my lord, my learned friend has filed an IA, my lord.
Lordship,
My lord, he is appearing for someone
there
else,
is
my lord.
a-
He is not a party to the writ petition, my lord.
Lordship, I have filed, let me say, may I please, your Lordship?
He is filing for impleading.
Pleading, yes, your Lordship.
Yes, I leave it to your lordship.
What
You have objection?
My lord, otherwise, my lord, all the, my lord, this matter was dealt by the official respondents, my lord. All are the official respondents, my lord.
The land in dispute, the land has, land is in dispute and title suit is pending. We have filed a title suit in Pujai.
We have placed an instruction dated 20/2024, my lord. Probably they were available on record. And last week it was not-
Copy to Mohammed.
Pending है sir. Copy नहीं हो रही है, copy तो कितने में दीजिए हम?
Yeah. What is your instruction?
It said regarding pendency of title issues between the parties. ma'am. For that reason, payment could not be released, my lord.
No, this is under Assam Mala.
Yes, ma'am. They have already.
Now, if it is Assam Mala, there has to be an agreement.
Yes, that is clearly mentioned. They have signed that Form C, my lord,
Who?
the petition number.
They have signed. Bring it on a record by affidavit, not by this. This is a very serious aspect.
Lordship.
Yes.
And why haven't you filed it? This is a matter of 2024.
On last occasion, petitioner was asked to brought instruction regarding this title suit, my lord, as they have.
No, the courts have, the courts have become here. And who are you?
My lord, I am the petitioner, my lord. The
No, who are you?
notice,
Lordship, this land on
First of
which,
all, you should come here,
yes.
not this way. That is the problem we are facing. Yes, tell me, who are you?
Lordship, the land on which they are claiming compensation, that land is in dispute. We are actually claiming that we are the owner. So we have filed a title suit before the honorable learned civil judge, no, Hojai.
No, if that is so, you say to be the owner.
Yes, your lordship. Our father purchased that land in 74. But they have illegally occupied that land for which title suit has been pending. But that was not disclosed in the writ petition. Your Lordship.
My lord, annexure 4 of the writ petition will clarify.
Heard, Mr.
I am.
The learned counsel appearing on behalf of the petitioner and Mr. So-and-so
Sir,
who appears on behalf of the petitioners. Ms. M. Borman appears on behalf of the state respondents. There is an application filed by the applicants claiming that they are the owners of the land upon which the petitioners herein are claiming compensation in respect to the land acquisition. It is relevant to take note of that the acquisition has been carried out under the Assam Mala project, which is a scheme of the government of Assam to acquire land on the basis of agreement. Considering the above, as there are interstate disputes between as regards the title of the land which have been acquired under the Assam Mala project, which are said to be acquired under the Assam Mala project, this court is of the opinion that applicants herein are necessary parties to the accompanying writ petition. Accordingly, this court impledes the applicants number 1 to 7 as the respondent number 5, 6, 7, 8, 9, 10, 11 to the accompanying writ petition. The learned counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days. And the registry shall, on the basis of the said memo of parties as well as the present order, make necessary changes in the cause title and update the same in the CIS. I stands disposed. You have copy of the writ petition?
No, Lordship. The copy may be
Why?
I have.
You have been appearing, you know everything, and you say you don't have a copy. You have a copy. I'll you affidavit.
Deeply obliged.
In view of the order passed by this court in IAC number 2850/2026, Mr. So-and-so accepts notice on behalf of the newly impleaded respondent number 5 to 11. An extra copy of the writ petition be served upon him by tomorrow.
But tomorrow is a holiday, my lord. Otherwise, my lord. If
Okay,
Monday,
no,
my lord.
by
Monday.
Monday, my lord.
by Monday.
Yes.
The counsel appearing on behalf of the respondent, newly impleaded respondent, submits that he would file an affidavit. This court have also taken note of the submission of Ms. M. Borman, the learned counsel, appearing on behalf of the petitioner respondents, who submits that on the basis of agreements entered into by the petitioner, the acquisition have been made under the Assam Mala project, but on account of the pendency of title suit number 28/2023, the payment has not been made, disbursed to the petitioners. It is the opinion of this court that the said aspect has to be brought on record by filing affidavit, enclosing therewith the agreements entered into with the petitioners, as well as the award made on the basis thereof. Full stop. In addition to that, in the affidavit, the valuation of the land as fixed by the direct purchase committee shall also be brought on record. Okay?
Deeply obliged.
List this matter again on 30th of September 2026.
Fine.
In the meantime, the respondents, the official respondents, as well as the private respondents shall bring on record their stand by filing the affidavit by 28th of September.
I'm deeply obliged.
Deeply appreciated. Mr. PK Deka, what has happened?
Yes, my lord. Till date, my lord, no affidavit has been filed by the authority. And even I am not aware who is exactly running the market at present. We don't know, my lord.
What?
May it please your lordship, we have received the PROCEED comment yesterday, my lord, from the council head of department BTC, my lord. May I kindly have a look? Waiting. Lordship, here it says that the tender, in paragraph number 5, my lord, the tender of Lalpur Open Weekly Market under Bechimari Development Block was held on 18/6/26 in the office of CHD Market and Fairs Department BTC. After the closure of the tender process, BDO Bechimari Development Block prepared the comparative statement of tender of the said market and forwarded the comparative statement of tender with tender papers to the Market Settlement Committee BTC for recommendation and settlement of market. The Market Settlement Committee BTC recommended the second highest bidder for settlement of market. On recommendation of the Market Settlement Committee BTC, the competent authorities of BTC has approved the comparative statement of tender for settlement of the said markets. The Market Settlement Committee BTC
So
after,
this is the reason.
but there is no such other reasons.
So we just allow his repetition. What
Lordship, may
about
pass
the
it.
respondent's service complete?
Yes, my lord. So far, private respondent is concerned.
I'm only
dusty
concerned
service,
with the private respondent.
he refused to accept the dusty.
You find the affidavit of service.
My lord, we have filed affidavit.
Huh?
It's on record, my lord. We have filed affidavit. On
You
the
received it? Also, okay. Today it has come up for the first time.
yes, my lord, after motion, my lord.
Huh?
Yes, second time.
Okay. Okay. The first time after notice.
Yes.
Heard Mr. PK Deka, the learned counsel, appearing on behalf of the petitioner. Ms. So-and-so appears on behalf of the
BTC.
BTC. Mr. S. Dutta appears on behalf of the respondent. This court have also taken note of the affidavit of service filed by the petitioner and taking into account the said affidavit of service and full stop. From a perusal of the said affidavit of service, it is apparent this court is of the opinion that the service can be deemed to be complete for the respondent number 5. Full stop. Accordingly, the service full stop. And accordingly, the service upon the respondent number 5 is deemed to be complete. Full stop. The present petition has been filed by the petitioner assailing the illegal and arbitrary actions on the part of the respondent number 3, 4, 234
234.
in settling the Lalpur Open Weekly Market in favor of the respondent number 5, though admittedly the respondent number 5 was the second highest bidder. The materials on record show that a notice inviting tender was issued on 27/5/2026. In the said notice inviting tender, various markets were put to sale, including the Lalpur Open Weekly Market under the Bechimari Development Block, Udalguri. It is very pertinent to take note of clause 13
Yes.
of the notice inviting tender, and the same is reproduced here in under. From a perusal of the said above quoted clause, it would be seen that the competent authority shall make settlement with the highest bidder if all the necessary documents and government revenue are found in order. It is further mentioned that if the settlement is not made in favor of the highest bidder, the competent authority has to record reasons in writing for doing so. Full stop. This court duly takes note of that the petitioner was the highest bidder, highest competent bidder, and the respondent number 5 was the second highest competent bidder. However, the respondent number 3 had issued a communication to the respondent number 4 dated 27/7/2026, thereby directing the respondent number 4 to enter into an agreement, lease, and execute a deed of agreement with the respondent number 5. This communication dated 27/6/2026 is the subject matter of challenge. When the writ petition was listed before this court on 14/8/2026, this court, while issuing notice, passed certain interim directions. The interim directions so passed were that the impugned communication dated 27/7/2026 issued by the respondent number 3 to the respondent number 4 shall remain stayed. Today, when the matter has been taken up, Ms. So-and-so appearing, who is the standing counsel of the BTC, has placed before this court an instruction issued by the respondent number 3 to the senior standing counsel of the BTC, which is kept on record and marked with the letter X. From a perusal of the said communication, it is seen that the reason why the respondent number 5 have been chosen to be granted has been chosen over the petitioner is because the Market Settlement Committee had recommended so. In the opinion of this court, the said reasons so assigned would not meet the touchstone, would not meet the requirements in terms with clause 13 of the notice inviting tender, which is reproduced hereunder. Apart from that, the action on the part of the respondents, number 2, 3, and 4, to grant the contract settlement in favor of the respondent number 5 is also illegal and arbitrary, for which the same is required to be interfered with. Accordingly, the writ petition stands disposed of with the following observations and directions. The impugned communication dated 27/7/2026 issued by the respondent number 3 to the respondent number 4 is set aside and quashed. The respondent number 3 and respondent number 4 are directed afresh to consider the comparative statements comparative statement in respect to the tender pertaining to Lipool open weekly market, and then take appropriate steps for settlement in accordance with law and the tender conditions.
May I please, Lordship? Lordship here will be filing a Wakala number and will be appearing for sole respondents. Lordship, may kindly grant us 2 weeks time to file an affidavit.
Yes, what is the violation?
My lord, violation, my lord, of order, my lord,
Lordship is against the interim order.
is an interim order, my lord, that was passed. Whereby no coercive action was directed to be taken against me, my lord.
And
But
what
even
happened?
then, they issued the notice, my lord. I'm coming to that, and now we have been also vacated from the said plot of land, my lord.
You've been vacated?
My lord.
You've been vacated?
Yes, now they have vacated. We have again filed another contempt, my lord.
When?
Just after that order, my lord, in the month of August, another contempt has been filed.
No. There's no allegation to that effect.
No, in this contempt, there is no, there is a different contempt. Now in this
I'm not
case,
concerned with different contention. I'm concerned here. In this case, have you been vacated?
no, in this case not vacated, but in this case, my lord, they have issued the notice, my lord.
The notice issuing is not contempt. Not to take coercive measures, does it means that not to take pass an order also?
They have,
No contempt. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the respondent. The present application has been filed alleging willful and deliberate violation to the order dated 23/2/2026 passed in WPC number 975/2026, whereby the learned coordinate bench of this court had directed that till the returnable date, no coercive action be taken against the petitioner. It is the allegation made in the instant petition, in the instant contempt application, that in pursuance to the order passed by this court on, is this order extended?
yeah, it may extended, my lord.
Where is it?
My lord, today it has been listed, my lord, along with
File to the auction. Item number?
Item number, my lord, 49 and 50. Item number 49.
49. What happened? The matter did not come up on 27.
It was not listed, it was listed on another date, my lord.
Huh?
On the particular date, matter remained left over, my lord.
So, there is no extension of the interim order.
But
Even on 12/8, no extension. It is the case of a petitioner that learned coordinate bench have directed that no coercive action be taken against the petitioner till the returnable date. The returnable date was fixed on 27/3/2026. So this court have duly taken note of the records of WPC number 975/2026, wherein it is seen that the interim order which was passed on 23/2/2026 was not extended. Even on 12/8/2026. Be that as it may, it is very pertinent, it is relevant to take note of the directions were passed not to take coercive measures would not bar the respondent authorities from passing appropriate for initiating any process or passing appropriate orders. In the instant case, the allegation is that on 26/6/2026, an order was passed that the current construction be dismantled and notice for dismantling and notice be issued for dismantling within 10 days of the receipt of the order. In the opinion of this court, the same would not come within the ambit of the directions passed not to take coercive measures. This court also inquired with the learned counsel appearing on behalf of the petitioner as to whether the petitioner have been as to whether the petitioner's construction has been dismantled, to which the learned counsel submits that no such steps have been taken. Considering the above, it is the opinion of this court that there is no case of willful or deliberate violation to the order passed by this court have been made out, for which the contempt proceeding stands dropped.
Well, only one thing, actually dismantle has taken place. Dismantle has taken place already in this petition we have not mentioned, but dismantle has taken place. Another contempt is filed in this case. Dismantle has taken place.
When?
In the month of August, in another contempt petition we have filed.
Line to beside you. No case made out. Okay, now come to these two matters, 4950. You are there, 4950.
Lawyer for contempt motion.
You're not for the state of Assam.
Lordship.
Who is appearing for 4950 respondents? Yes, 49 argue.
49, my lord, here actually was that, my lord. I'm in possession of a government plot of land, my lord. Thereafter, my lord, some private respondents, my lord, they tried to evict me from the state plot of land.
In this
There,
matter, my lord, Mr. BJ Talukdar is appearing, he is on legs. Mr. BJ Talukdar is appearing, my lord.
Who?
BJ Talukdar, additional senior government deputy. He is on legs in 4-6 miles. Maybe.
All government advocates for me is the same. You
Lordship.
can also appear. Yes. What is your case?
my lord, in item number 49, my
This
lord,
one, filed by this one, 3889.
389. 389, my lord. In this case, my lord, the same allegation has been made, but whatever is that, my lord, here we have.
Respondent authorities not to evict the petitioners from the land occupied by him under DAG number 13.
Yes.
Why? Why?
My lord, actually, in this case, my lord, no proper notice was issued, my lord.
Their notice was issued. So what is your wrong?
my lord, actually, this process was has been initiated at the behest of some private person.
On the public field on government land, Iman are also held in Iman Hall by being on this land. So that you have been illegally upon the specific public field. If you possess valid permission from the GMC or the GMDA on this land, a hearing has been scheduled to be held. Strictly marked. Then written statement. Then you file a suit
I filed a suit, my lord. In the suit, my lord, some injunction was also granted, my lord.
And
Then this person against again, my lord, they approached the circle officer and my lord filed
restraining
petition,
the
my lord.
opposite party from the suit was filed against whom?
Suit was against the private respondents, my lord.
So that has no relevance. Then
My lord, they initiated the process initially, that is at writ petition number 975. And thereafter, my lord, and
975 is okay.
then, my lord,
What is wrong?
then again, my lord, this order has been passed, my lord. This impugn order, my lord, that no, they again initiated the process for evicting me.
Then
My lord, the impugn.
who is encroaching upon the government land?
Then the impugn order was passed, my lord, at page 77, my lord. Against that, my lord, we have come.
So
my
what
lord.
is wrong with this order? You don't get a right because of an order passed by the court. The right has to be there from somewhere.
My
What is wrong with the order?
My wrong means, my lord, they have not issued the notice as,
What notice? Notice has been
as-
issued to you.
as required under
Notice has
Rule
been
18, my
issued to
lord.
you directly in that you kindly obtain, provide us the details on what basis you have constructed on the public road, public field, which is reserved for holding some programs of this Gopal Mandir or something.
Uh,
Then
my lord,
you are in government land.
my lord,
You cannot get a settlement of that land. Then what is there? No case. Bad case.
but as per Rule 18 my lord, the settlement rules, they have not served the notice.
Have you been evicted?
Now evicted, my lord. That is why we filed another contempt we have filed.
It's okay. Where is that evicted? Ordered that in the interim there shall not be any further action against the petitioner quod or subject per the year in terms of the year till the returnable date. When were you evicted?
My lord, that is in the contempt petition we have mentioned, but today that contempt is not before his honorable court, so we have not brought the file.
So if you are evicted, the interim order has become infructuous.
Yes, my lord. We have filed contempt. That is why we filed contempt, my lord. Another contempt we have filed, my lord.
Where is your statement that you have been evicted? No.
No. When this writ petition was filed, we have not evicted. But,
So
but
both
after
the writ petition has become infructuous then. Nothing remains. What remains?
my lord, it may be listed after next week. It may be listed. I will produce the record of that other contempt case, my lord.
Don't worry, we'll call for the contempt immediately.
My lord.
We call for a contempt immediately. Your writ petitions have become that interim order cannot be there. You have been evicted, so it's a fresh cause of action. What remains in these writ petitions? The challenge you are making to that particular order. Here the notice was given to you. You are in government land. Number 3 is that government land is reserved for a particular purpose where you cannot get a settlement. Number 4 is you don't have any GMC or anybody is giving you the permission to construct also. What is the basis?
There is no permanent construction, is not there, my lord.
So what is dismantle is the tin construction. You make again. Have you carried back your tin construction or not? Or they didn't give you that also?
That is lying there, my lord.
Take over. Use it for some other purpose. Some other land. Government has lots of land. Okay. How can we extend the interim order also? And what is 975? 975 has become infructuous.
Yes. That was the initial case.
Because after 975, the order has been passed.
Order has been passed.
24/6.
Yes.
24/6 order has been passed, but because the court did not stop it from passing the stay order, there has to be a stay, not coercive measures is a very, therefore the order of 3889 is good order. Not to take any steps in respect to the subject plot of land. But in respect to this, nothing remains. We close this contempt, 975, keep this, not extend. Okay?
Yes, sir.
Hello. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous in view of the passing of the order dated 24/6/2026, as well as the subsequent actions to taken, including the filing of the writ petition being the application number 3889/2026. He therefore submits that the writ petition may be closed without prejudice to the rights of the petitioner in WPC number 3889/2026. Accordingly, the writ petition being the instant writ petition stands closed as infructuous. However, the closing of the writ petition as infructuous shall not prejudice the petitioner in WPC number 3889/2026. That goes. Now come to 3889.
No, my lord, here, our case is that, my lord,
Your injunction is against somebody. You have no relevance. Who is appearing for the private respondents?
private respondents,
I'm not the private respondent.
You have overthrown him. Who are you?
I'm was 6 to 11, my lord.
Understood, but who are you?
Actually, we are the villager, my lord.
Villager in Gauhati?
That place, my lord. That area, my lord.
Jalukbari, Khodilapur.
Kodilapur.
Jalukbari, Khodilapur.
TMC goes there then. TMC is not there.
James is there, my lord.
TMC is then
What about number 1 ward?
then it is not a villager.
That's the town.
Okay, now tell me what has happened? Why you are disturbing the petitioner?
No, my lord, this is the false allegation, my lord, against us. Actually, that place was used for Bhogghar, my lord. There is a Namghar. Suddenly, the petitioner built a house. Concerned with this villager, already they have applied for government money. In the meantime, they have allotted money from the government, 1,50,000. When they are going to construction the temporary house for Bhogghar of the Namghar, my lord, then he built a house, tin, and the construction the temporary house, my lord. This is the fact.
No, we are there from the very beginning. In fact, the Namghar, which is located, is situated over our plot of land, my lord.
No, but the Namghar was established.
Your plot of land means it is
Yes,
exactly a government land.
No, Namghar is in
No,
the
this is
private land.
Ah.
Opposite to the Namghar, there is a plot of land which I have been using for last more than 30 years, my lord. And they want to take over that land, so we filed an injunction case. After that injunction case, they approached the circle officer and filed petition, my lord.
But you have an injunction there.
We have injunction against them, my lord.
Very well. What is here to do?
Man, here, my lord.
Namghar is established, my lord. Just 1 minute. Namghar is established 1950, my lord. And he sold the plot, brought the plot to 2013. As per
30, my lord.
record.
Not as per record. That land belongs to our family, my lord. So that in that land, my lord, we have allowed.
You have given the land to the Namghar, so now you want to.
No, we have not. We are not taking the Namghar, my lord.
You want
Opposite-
to occupy the land in front of the Namghar.
No. Everybody is means
There-
doing some
there-
calculation, my lord.
Patta land
near
is
the
just
Brahmaputra
below
river and
his residence, my lord.
Opposite to our residence, my lord, there is a Brahmaputra river. By the side of the Brahmaputra, there is some land, my lord. In this land, my lord, we are doing some cultivation. Not only we, they are also doing cultivation, and they have also made construction over there, that land also. And we have made complaint against them, but no action has been taken against them, my lord. We have made complaint to
As
them.
a false allegation against us, this we
Anyway,
are going to
one
make
thing.
this a
You are
Gauhati, my lord.
Wait, you file your affidavit.
Yes, my lord.
But as you are now being evicted, interim order has no relevance.
No.
So You file your affidavit and government, what is your stand?
Instruction yet not disseminated. Because earlier communication was not sent on our part.
You have evicted him in the month of August, and now you are saying instructions are awaited. Does it look good?
I'm afraid to say, my lord, in these cases, my lord, earlier attending council did not send any communication, my lord, on our, I apologize for.
After getting that order, the council did not send.
Lordship, no communication I found in my office file. I do apologize for that.
Mr. J. Hendig was appearing.
No, Mr. DJ Tadkar was there for one. He is for review.
He did not inform the department.
No. That difficulty on
Hello. Mr. So-and-so appears on behalf of the respondent numbers 6 to
11.
11. Ms. M. Borman appears on behalf of the district administration. The respondents are directed to bring on record their stand by filing the affidavits on or before 16th of September 2026. Petitioner granted liberty to file reply thereagainst by 23rd of September 2026. List this matter on 30th of September 2026. Taking into account the submission made by Mr. I. Chaudhary, the learned counsel for the petitioner, that the petitioner has already been evicted from the subject plot of land, this court is not inclined to extend the interim directions.
Right.
What is this bank account freezing?
My lordship, I'm government teacher, my lordship, and this is my salaried account, my lordship. And all of a sudden, this account has been blocked.
Yes,
my
Mr. Parvez, what has happened?
Your lordship, I have instruction. I need 2 weeks time to file affidavit.
What has happened?
Yes, sir, we have freeze the account as per the instruction received
How
from the
much?
cyber truck.
What
It
the
is about 11,10,000. So,
disputed?
yes, my lord.
Huh?
My
No,
lord,
14
we
lakh.
don't know anything. No information has
14
been
lakh
given.
5,000.
Is in his account.
No, it is not in the account, but the authority has freezed this amount. So we have marked lien on that.
What?
I have children, my lordship. At least I should get my salary, my lordship. I can hold everything.
Para 4, my lord.
In fact, what crime has been done, we don't know, my lordship.
You file your affidavit
Yes, sir.
along with those documents, huh? Because there is a particular reference to a document. You need to file an affidavit.
Even my lordship,
Where you-
I don't know.
Mr. A. Parvez, the learned counsel appearing on behalf of the petitioner for the State Bank of India, submits that 2 weeks' time may be granted to
My
the
lord, Punjab National Bank.
Punjab National Bank. All these banks rotate around you councils. Either you are there or Mr. M. Sharma is there. Either central.
Actually, there is no here in the Punjab National Bank. I am the standing counsel, so all matter will come through me. But in State Bank, they rotate.
Okay, Mr. A. Parvez, the learned counsel appearing on behalf of the respondent numbers 1, 2, and 3, submits that he has received the instructions and the affidavit would be filed within 2 weeks' time. Mr. S.B. Loskor, the learned counsels appearing on behalf of the petitioner, submitted. The petitioner is a retired teacher.
No, my lordship, in
He's a
service
teacher.
Lady, my lordship.
And his salary account has been
Her, my lordship.
salary account.
She's a lady teacher. Her.
Lady, what else can it happen?
My lordship.
Lady special circumstances has
No,
to be
no,
given.
no, my lordship.
Then for all lady cases and lady advocates should appear.
No.
Then the petitioner salary account has been frozen. Taking into account the above, list this matter on 18th of September 2026. In the meantime, the affidavit on behalf of the respondents be filed on or before 14th of September.
My lordship, I cannot give fees to my children, my lordship.
What?
Even I cannot give fees of my children's school.
No, no,
education.
Mr. Counsel, the problem lies there. You have 11 lakhs and there is a direction to freeze 14 lakhs. Problem lies there. If it was less, I could have allowed you.
Even I don't know what crime, my lordship, cyber crime is there, my lord. No,
Let us see the crime. You have only, the notice was issued only in the month of June. Let us see the crime. What has happened? Whether you produce your bank account statement, have you produced it in your petition?
Account statement, my lordship. I have not-
Why haven't you not enclosed?
My lordship.
Next.
May I please, my lord?
What is this matter about?
My lord, this matter relates to land acquisition, my lord, and grievance of the petitioner is that, my lord, while calculating the compensation, my lord, the entire structures are not considered, my lord.
So, wait. So, go there, 3G5. This court has no business out there.
But,
No, you are converting this court into a 3G court.
no, I'm not.
Am I a competent? Do I look like the competent authority?
I'm not saying, my lord.
Look at this.
My lord, my case is that.
No. Your case, structure is not taken, 3G5. No case. Not here. Because of all these type of litigations, there are many cases where court date benches have been passing order to the effect, asking the DC or the Scala to again reassess. Once he passes an award, the matter is over for him. The only way is by way of the statute provides the arbitrator can look into it. Nobody else. What a 3G5. Heard Mr. A.K. Gupta, the learning counsel, appearing on behalf of the petitioner. Mr. You are appearing for? None appears on behalf of the respondent number 1. So-and-so appears for respondent number 2. Mr. Endas appears for the respondent number 3.
5, my lord.
None, 3,
5, my lord.
5. None appears for respondent number 4 and 6. The present petition has been filed by the petitioner being aggrieved by the assessment made under section 3G 1 by the competent authority
No,
without taking into account the dwelling house.
yes, my lord, the structure, first floor and the, my lord, one Assam type structure is there, that is not considered.
Without taking into consideration the cost of the, without taking into consideration properly the cost, the compensation, without taking into consideration the Jirat value of the standing structures. This court have duly taken note of the provisions of section 3G of the Act of 1956, which stipulates the manner in which the compensation is to be assessed by the competent authority of land acquisition as well as by the arbitrator upon a reference being made under section 3G5. It is also of relevance to take note of that once the award has been passed by the competent authority, the remedy of the petitioner or of the person aggrieved as regards the inadequacy of compensation lies in filing an application seeking reference to the arbitration in terms with section 3G5 In the instant case, taking into account that an award has been passed and the petitioner is aggrieved by the inadequacy of the compensation, and there being statutory remedies provided in that regard, this court is not inclined to entertain the instant writ petition. Accordingly, the writ petition stands closed. Before parting with the record, this court, however, observes that the closure of the instant writ petition shall not preclude or prejudice the petitioner to approach to seek a reference to the arbitration in terms with Section 3G5 of the Act of 1956, and the learned arbitrator in doing so shall not only take into consideration the provisions of Section 3G7 of the Act of 1956, but also the provisions of Section 26 to 30 of the Right to Fair Compensation 2013, as it is the mandate of the Supreme Court in the case of so-and-so reported in 2022, 15 SCC page 1. Yes, what happened to the petitioner in person? You are there?
I am for respondent 1 and 2, Lordship, Bar Council.
Allegation is against you?
No, Lordship. I have been made party that I am not taking any action on the complaint, but Lordship, in this case, we have issued notice to the.
Action against whom?
Against one advocate, Lordship.
And the advocate is not a party?
No.
How is it possible?
Because
And this is being filed by another advocate?
no, Lordship, that.
Who is this?
client.
Have you taken any action?
So I have issued notice, but notice was refused that out of station, and one notice was issued by hand to his junior. After receiving that, he has again returned that notice. So we are contemplating to place this matter before the full committee of the Bar Council, which has not been yet constituted. And on the next week, Lordship, there is a meeting of Honorable Chief Justice of this High Court for nomination of 2 distinguished member. One is judge, retired judge, and one for lady senior advocate. After that only that we can take note of this application.
Mr. PP Datta appear, but the petition has not been framed in a proper manner. Without, how can we direct initiation of any proceedings against somebody who is not a party?
That's it.
Isn't it?
That,
What do you say? What should I
yes,
do?
Lordship. So now he,
If you are standing here, what should I do? Tell me.
Lordship, today will on written instruction I will place Lordship regarding the.
Okay, Mr. PP Datta appearing on behalf of the respondent number 1 and 2 submits that he will provide the written instruction as to what steps have been taken by the respondent number 1 and 2 in pursuance to the complaint submitted by the petitioner against the concerned advocate. To establish this matter again on 25th of September 2026. On the next date, the necessary instructions be placed.
Obliged, Lordship.
Mr. Hawk, where is he? What is this matter, Mr. Talukdar?
Lordship, Lordship, one difficulty is whether the office has misplaced the file. Lordship, I'll reconstruct and send it to the authority for instruction.
What order is he sealed?
Cancellation.
Set aside the order passed by the additional deputy commissioner to direct the district commissioner to accept the land position of so-and-so to forbid in the year not to disturb the position of Iman. Direct the director to re-verify the land report. What is the order of the district commissioner? Reports so-and-so. How the If he's aggrieved by this, don't you think that he should go before the Board of Revenue?
My lord, lordship, I have just now, I have seen, and brief was not there. I am going through it. This is, my lord,
Where is Mr. This is S. Hawk. Okay, today we dismiss it. We'll find it. Call S. Hawk.
yes.
My lord, account freeze, lordship. Statement I have annexed, my lord, page 19. There is whole value is, my lord, 5,48,776. And other balance, my lord, 3,48,690 is there.
We close it. You go to the SOP. SOP business. Go to the SOP.
My lord,
To the particular year, you will initiate the process under the grievance redressal mechanism in terms with the SOP of 2/1/2026. They will complete it within 90 days.
my lord,
The only grievance is that only. You have a current account out here,
my lord,
and your current account has 9 lakhs.
9 lakhs.
Some disputed amount of 4 lakhs.
That may be kept on lien, my lord.
What is it?
Other amount may be
We are
released.
preparing for the first time on behalf of bank lords.
They are paying for
For the first time lordship,
from
SBI lordship.
My lord, as I have annexed one order, lordship has passed, my lord. The
I
lien,
have passed many orders, but
Why?
that is a better year. Can you see in the big TV in front?
lordship,
Yes, you know that. Better go there. Within 90 days, that is completed. Better off. Because if you notice, ask him to do all these things, they will file affidavit. After affidavit, you may file reply.
I think close 10, lordship. SOP close 10 maybe.
Huh?
My remedy may be in close 10 of the SOP.
What?
In the SOP, my lord, close 10 may be applicable for.
Yes. Chapter 3. Better of that is the better.
But that is the lengthy process.
No, 90 days. That is only 90 days. But then it will become easier because they will make the inquiry and finish it off. You want to do it, or we can ask him to file reply. 4 weeks. 4 weeks reply. Then they will file over. And when was it done?
It was, my lord, in the month of April.
April. Because the Supreme Court, in view of that, what has happened, they have approached this SOP is being made on the basis of some Supreme Court directions.
But Supreme Court also said, my lord, there is no absolute bar in entertaining.
There's no question. This court can very well pass that order. But at the end of the day, this amount of this 5 lakhs, you would not get it. This court can only pass an order that keep this on lien till the direction is given by the cyber.
Lordship.
Now this cyber, you never know when they will give.
I'll leave it to the lordship. I'll leave it to the lordship.
You don't leave it to me. Think about it. But these are otherwise the orders which have passed. Because these are small amounts. You see, the order which you have enclosed is just 2,000.
2,000.
But here it's a case of 5 lakhs. Because 5 lakhs keeping on lien for a long time, it will affect you. No?
Lordship.
I think SOP would be better.
If they, my lord, consider it within 90 days that.
No, that's the mandate. Within so and so time, this will happen in so and so. Okay, let me pass the order.
Lordship.
Heard Mr. So and so, the learned counsel appearing on behalf of the petitioner. Petitioners. Who has the account?
Both the
joint account?
Joint account, my lord. Joint account.
Full stop. Miss so and so appears on behalf of the respondent number 1, 4, and 5. The petitioners herein are carrying on the business in the name and style of JK Enterprise. the said business entity of the petitioner is maintaining a savings current bank account with the respondent number 1 in the branch of the respondent number 5. The bank account of the petitioner, the current bank account of the petitioner is SBI, is number 44306995468. It is the case of the petitioner that without providing any intimation, the said bank account has been frozen by the respondent number 5, by respondent number 1, 3, and 5. So the petitioners made inquiry and could come to learn that on account of an amount of rupees 5,84,776 being disputed, out of the total amount of rupees 9,33,000 disputed, the said bank account have been frozen. It is the case of the petitioner that the petitioner has 9,33,466. This court have also heard the learned counsel appearing on behalf of the petitioner respondents who had submitted that what is Annexure 3?
Account statement, madam. It's a computer generated statement.
Who submits that there is a requirement of carrying out necessary inquiry in respect to the disputed deposit, which is to the tune of rupees 5,84,776, as would be apparent from Annexure 3 to the writ petition. This court duly takes note of. SOP call? Reading good. একদম পড়লে যাও, একদম পড়লে যাও, ফার্স্ট পেজলে যাও, আর উপর এইটো. This court duly takes note of. That the Ministry of Home Affairs has issued a standard operating procedure (SOP) for NCRP-CFC FRMS, custody, restoration of money and grievance redressal, dated 2/1/2026. Chapter 3 Lehok. Section 3 of the said SOP provides the grievance redressal mechanism and provides full stop. This court have peruse clause 10 of the said SOP, which is the grievance redressal mechanism, and a perusal thereof, it is seen that there is a effective and efficacious remedy available to the petitioner by which the by which due inquiry can be carried out and completed within a period of 90 days as stated therein. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. The petitioner herein is granted the liberty to approach the respondent number 5, placing a complaint as regards the freezing of the petitioner's bank account bearing number so and so. The respondent number 5 thereupon shall initiate the grievance redressal mechanism and take further steps so that the grievance of the petitioner can be brought to a logical conclusion within the time period mentioned therein. Yes, what is this?
Lord, we have served the copy to my learned friends.
Only yesterday at 3 p.m.
Yes, yes.
What?
So unable to get the instructions, Lordship.
At 3 p.m.
My file was missing. Somehow trace out. Immediately I have given the copy.
But what is your case?
The mother,
Are you still there?
The authority has given me rupees 12 lakh and balance amount for without any opportunity of giving, opportunity of hearing that such taken some cheap number of Malad.
First and foremost is whether this is a case of land acquisition.
Land acquisition budget.
Land has been acquired or not?
Acquired.
No, then what is there?
No, acquired. They what they have done.
How can you remain in possession?
No. They acquired the first. This is my statement.
That was the query made on the earlier date that
Paragraph
whether
10.
eviction has been carried out or not.
Eviction was suspended because
Eviction was never suspended.
but stay notice was suspended.
Notice of eviction was suspended because why they were taking eviction? Because the land has been acquired and you are not giving it.
No money was paid to us.
That is a different case. No. First of all, can you say on account of the money not being paid to you,
My lord.
the land does not vest upon the state? You are not entitled for compensation
No,
also.
my lord, I am wrong.
Yes.
Kindly see paragraph.
No case.
Just a minute. Paragraph 8.
And there is no interim order since 2018.
That is why, and I also did not get the instruction, present instruction, but lordship kindly see, yes.
This is to inform you that you are unauthorizedly occupying a plot of land on National Highway 31 by constructing house. Removed. Good. You should be removed from there. That is the National Highways land. There's no business out there. There's a process for National Highway, no? That particular, when there is an unauthorized construction of a National Highway, there is a particular rule. Who is paying for National Highway?
Copy has not been served to us.
Forget about a copy. Do you know the law?
No, we have served the copy yesterday.
National Highway.
Yes, the Control of National Highway Land and Traffic Act 2002. If the person is in occupation, prevention of occupation of the area, highway on the authorized area under subsection may on an application made by the person having regard to the safety of their grant permission. And no permission shall be valid for a period of a year. There was no business out there. Highway land to be deemed as property of the central government. You are out.
No, lordship kindly see para 10 of my petition.
The petition would not help you.
No,
No,
lord,
Mr. On that day, Mr. Saikia, do you know that why I have asked them instruction?
My lord.
Only because your junior had come.
Lordship.
And I did not want to dismiss it in her hands.
My lord.
There was nothing to take instruction.
This is the
I
guidance.
told her on that very day that if your senior would have come, would have dismissed it on the face of it on that day itself. But because of your junior, I did not ask her.
No, this
This was to be no, Mr. Saikia, your case should have been dismissed in the year 2018.
Lordship,
You have prolonged the period.
no, Lordship will dismiss
by
it. Only my submission may be accorded.
Yes.
Lordship,
What
kindly
is your- what is your submission?
Submission by paragraph 10.
Ah,
Paragraph 10 of this case.
what is that?
At page 8 of my petition, paragraph 10. That the petitioner was never informed about the rate of compensation of the acquired land, building trees, boundary walls, giraffes, and the petitioner was completely dark, kept in dark as to how the compensation works out by the competent authority. As such, the petitioner did not accept the compensation of rupees 5,35,200 in respect of the acquisition of the land measuring 2 kotha, 2 lesa. They made their own calculation. They did not allow me to press my case. That is why I filed an appeal. Appeal may be seen. Appeal was allowed, my lord, by the arbitrator at page 23.
What did he say?
Page 23, my lord. Order of the Commissioner of Lower Assam Division. Page 23. There is the appeal filed by Mr. Mukul Daka in connection with the
So
acquisition.
here is only the question of payment.
The question of determination of the value.
No, maybe
Lordship.
it's a question of payment.
No, not only that. They kindly see, my lord, this appeal was allowed. They did not act as per the order of the appellate authority. My lord, kindly see. Where is the appeal petition filed by C. Dhaka? Then paragraph 1, that the acquisition of the land was made, but his objection petition was not heard before the acquisition, that he has not received adequate compensation for his land that has been acquired, that his land which was acquired and categorized as residential land, while computing the compensation, although the land is actually classified as commercial land. Heard the petitioner, the national, then my lord kindly say below person. Heard the appellant as well as the representative of the competent authority. On perusal of the records and after careful examination, the following issues have been noticed.
Anyways,
My lord.
if you,
Number
Mr.
number
Sharma,
three.
Mr. Sharma and all, if the petitioner is still possessing it, vacate it. Immediately evict them.
I am in possession, lordship.
Evict him.
No, lordship kindly see.
No.
When the lordship
You
will kindly-
evict him and give a
No,
report
lordship
before
will
it.
kindly
No,
bear with me.
No, Mr.
No, lordship will pass the order.
I'm passing it.
No, lordship will have
Heard
some,
Mr.
have
R.C.
some
Sheikh.
little patience.
No,
lordship.
Mr. R.C.
Kindly see.
Heard
When-
Mr. R.C. Sheikh,
No,
the
my lord,
learned
just a
counsel
minute, just
appearing
a
on
minute.
behalf of.
Just a minute, my lord, just a minute.
So and so appear, you have a junior assisting you?
Yes.
What is your name? So and so appearing, assisting. Mr. So and so appears on behalf of so and so appears for respond number 1. Mr. So and so appears for respond number 2 and 3.
2, 3, and 5.
Huh? 2 and
2, 3, and 5.
3 and
5 circle office.
Mr. So and so appears for respondent number 4. The present petition has been filed by the petitioner, being aggrieved by the issuance of a notice dated 24/2018, issued by the Circle Officer, Balaji Revenue Circle, directing the petitioner to immediately vacate the land plot of land which is standing on the National Highway number 31 by constructing shop / house, tempo stand, mini truck stand. It is the case of the petitioner that though the land have been acquired, but the compensation have not been paid. And as such, the notice dated 24/2018 passed by the Circle Officer, Bozali Revenue Circle, is required to be interfered with. It is the further case of the petitioner that direction may be issued to the competent authority of land acquisition to release the compensation of the acquisition of the land, building and Jirat as per the direction of the Commissioner, Lower Assam Division, Gauhati. This court have duly taken note of that the land of the petitioner was acquired and the compensation was assessed at rupees 5,04,000 for the land and rupees 31,200 for the Jirat. In total, rupees 5,35,200. However, it is the claim of the petitioner that the amount so paid to the petitioner was inadequate. And as such, the petitioner filed an application under section 3G5 of the National Highways Act 1956, for short the Act of 1956. In the said proceedings, the arbitrator who have been duly appointed by the central government passed an order on 24/2/2014 thereby directing the competent authority to revise the assessment on the basis of the observations made in the said order dated 24/2/2014 and pay the compensation accordingly. It is the case of the petitioner that thereupon there has been an additional sanction of an amount of rupees 29,93,607. However, no payment was made for which no payment was made. It is the further case of the petitioner that in spite of non-payment not being made, notice was issued by the respondent number 5 on 24/2018, thereby asking the petitioner to vacate. This court have given an anxious consideration to the materials on record. The land having been acquired by issuance of notification under section 3D of the Act of 1956, the land vests with the central government by operation of law. The petitioner has no right to remain in possession of the said land. Accordingly, it is therefore the opinion of this court that the question of interference with the notice dated 24/2018 does not arise. The respondents herein are granted the liberty to take effective steps for eviction of the petitioner in that regard. There is the second aspect of the matter, which is the non-payment of the dues to the petitioner. The learned counsel is appearing on behalf of the National Highway Authority of India, as well as the competent authority of land acquisition, shall apprise this court on the next date as to why the petitioner have not yet been paid the dues. It may not be out of place to mention. Yeah, dues. Have not been paid the compensation dues now. Huh? List this matter again on 30th of September 2026. You have got a copy of the petition?
Yes, I have given. Again, I will give that.
Give it to him right now.
We have got a copy.
Yes.
Lordship,
You have not got it?
Lordship, they have served to our client yesterday, Lordship. I have seen the note, but we have not.
Given it.
My lord, just a minute, Lordship. Page 24, Lordship, the arbitrator has directed them to treat the land as commercial and to pay the solution. These two things are not done by them. They treated it as residential, or it is a commercial land. That was the grievance of the petitioner. my lord.
Mr. R.C. Soikia, I have made that only.
Lordship,
Ask them why they have not paid.
my lord,
In the meantime, throw them out.
Lordship. Obliged, Lordship. Or obliged. That will do.
Yes, Mr. Sharma.
Lord, have taken steps, my lord, as per your lordship's last order, dated
What is that?
22 to the newly impleted respondent, my lord.
Lordship, I have appeared for respondent number 6.
You have taken steps.
My lord, we've taken steps. We have yet to file our dusty, my lord. In fact, we have engaged our clerk to go to the site of respondent number 6, and we have filed our affidavit stating that
You are responding.
Respondent number 6, Lordship. I have filed my call on today.
Now, what is your case?
2 weeks time may be granted. We will file affidavit, Lordship.
Wait. What is your case?
my case is that this was a tender which was floated by the state authorities, my lord, for supply of diet, my lord, of hospital diet, my lord. Now, pursuant to that, my lord, there were two clauses in the tender, my lord, which debarred me at the very outset. Those two clauses are that I need to have a GST registration in the state of Assam for the past 5 years. It effectively implies that I need to have a past experience. My lord, may kindly come to page 39, my lord.
Anyways, I did not pass an interim order.
No, my lord. On 1812, your lordship had held that if your lordship finds the clauses to be arbitrary, my lord, your lordship would be pleased to set aside the tender.
Only one clause, clause 2C.
2C read with other, the additional, the same, my lord. The effect is the same, that I need to have a GST registration in the state of Assam. My point is that that clause has no nexus to the terms of the tender.
I got that, yes, your case. There is one judgment of the Supreme Court.
Utkarsh Enterprises, my lord, this has been held.
Which one?
My lord, in Utkarsh Enterprises, there was a reference to another judgment, my lord, Vinisha Technologies Private Limited.
Vinisha said that you cannot.
My lord.
But the recent judgment says
My lord.
where they were asking for having the establishment within the particular area,
My lord.
the Supreme Court says that that is reasonable.
So that is reasonable. The fact is they have asked for two things. First is that I need to have a GST registration, and that I need to have the ability to open a local office, an ability to open a local office.
You don't have the ability.
I do.
Then
the fact is, but I was ousted at the very threshold, my lord, that I could not compete. When the matter was moved on 18th, 18th was the last date for filing of the tender, my lord. And your lordship had held that your lordship would not.
Why have you moved it on the last date?
No, my lord, that was
it not advertised properly?
It was advertised, my lord. But your lordship had heard the matter on 18th, my lord, and lordship had will hear the matter.
You file it at the last moment. Whoa. How can one help it? You should have come earlier.
No, but your lordship had gotten through that part of the averment, my lord. Your lordship had passed
But
the order.
this recent judgment of, I think, Justice Vishwanathan,
My lord, I'll go through because I have also looked onto it the fact of past experience. In fact, the GST registration would also include past experience because unless I have done business in Assam, I'll not have the registration in the state of Assam. That is the ground I've taken. And
Obviously.
yes, and they state that being familiar with the local cuisine and palate is important to provide food, my lord. That, to my understanding, my lord, since we are dealing with a hospital and a medical institution, the taste of
You'll give out here to the hospital a sambar dosa.
no, that is that is the point, my lord. That is the point. No, that is their point. That is the state's point. My point is that, my lord, the diet for a hospital, my lord, has to be medically approved, my lord. It does not really matter to taste, my lord. So,
Okay. We do one thing.
my lord,
We have got the contract.
Lordship.
Happy.
We are working.
Do one thing. You file your affidavit.
We are filing affidavit, Lordship.
And state has filed the affidavit.
Lordship,
they have, my
filed.
lord.
State have filed.
We have filed a reply to that also, my lord.
So what is there?
Lordship, we want to bring some documents on record. 2 weeks time may be granted, Lordship.
Mr. Pathak, who is there online,
Yes, sir.
your matter is over. We have fixed it on
So,
25th.
sorry, sir. That was the technical issue, Your Honor.
It's okay. I fixed the matter. In the meantime, the Bar Council is taking up your action.
Okay,
They
sir.
are taking and they will submit a report on the next date.
Okay, sir. Thank you. Thank you.
এইটো খালি petitioner in person is present কৰি দিব এইটো পিপি দত্ত এপিয়া কৰিছিল just okay so we do one thing Mr. So don't take much time so submits that within 2 weeks the affidavit would be filed on behalf of the private respondent who established this matter again on 18th of September 18 বহুত হৈছে নেকি matter I'm told that yes till yesterday it was 44 45, not there. 23rd of September. In the meantime, the affidavit will be filed on 18th September, by 18th September.
Obliged,
Liberty given to the petitioner to file reply delegates.
Hello, I'm grateful, man.
With this, my lord. My lord, am I audible?
Yes.
Yes, my lord. The petitioner herein is challenging the legality and validity of the advertisement dated 19th May 2026, Lordship, for 6 posts of judicial assistance in the Gauhati High Court, Kohima.
Challenging?
Yes, Lordship.
Yes. What are you challenging?
Now, to the limited extent that 2 posts, one each for Konyak tribe and Home tribe, were reserved out of the 6 posts, Lordship, without a specific reservation policy, Lordship, for the employees of the High Court, Lordships. Now, the impugned advertisement does not cite, refer, or purport to adopt any policy of the state of Nagaland to that effect, Lordships. It simply lists Konyak and Pom tribe as a reserved category, Lordships. So the petitioner herein is aggrieved by that, Lordships. Now, the rules of 1967 does not provide for any reservation policy, Lordships. And it also does not delegate power to any authority to further subclassify a category for reservation, Lordships. Now, herein the petition, Lordship, 3 substantial questions are being raised by the petitioner herein, Lordship. Now, the first question is, what was the rationale behind in giving specific reservation to Konyak, specific tribe reservation to Konyak tribe and Pom tribe of the state of Nagaland, Lordship? Second is whether the High Court, being a constitutional body, will be governed by the reservation policy of the state of Nagaland. Now, the third question is whether the reservation policy of the state of Nagaland, without a specific adoption by the Gauhati High Court, can be applied mechanically to the recruitment process of the Gauhati High Court, Lordships. So this is the 3 substantial questions being raised in this instant writ petition, Lordships. Now, the only herein, Lordship, there is no notification to that effect to the best ability possible, Lordship, the petitioner has tried to dig out, but there has been no such notification adopting the state.
We do one thing, Mr. Council.
Lordship.
We issue notice and let us see what happens.
Yes, Lordship.
But there is no specifically in the advertisement, there is no mention that it is the cognac or the which is the other one? Form.
Home tribe, Lordship. Two
Form.
forms have
So
been
no
reserved for
mention
them.
to the effect shall indigenous scheduled tribe inhabitants of the state of Nagaland.
Yes, Lordship.
So we will consider, let us see after hearing the government as well as also the Gauhati High Court.
Government
Let
is
us
not
look
made
into
party.
it. Huh?
Government is not made party here.
Made a
But
part. Yes,
Mr.
Lordship.
Council,
Yes,
I
Lordship.
know that you are a very good counsel. What has happened?
Lordship, here the limited question is to
Whatever may be, no. You see,
yes, Lordship.
the council, you have to understand, the reservation is not made by the High Court.
Yes, Lordship.
The reservation stems from the government. And apart from that, whether these home tribes as well as are recognized tribes in terms with the Schedule Tribes Order 1952 or 51. That is one thing. Secondly, the government has whether it is now being done, whether they home and the
Cognac,
other
Lordship. Cognac.
cognac, they are otherwise scheduled tribes or inhabitants of the state of Nagaland, unless you show that from the state of the Scheduled Tribe Order of 1950 or 51, there is not there is no recognition.
My Lord.
Because if there is a recognition out there in that order, there is no way out you can bring it out. The court has no power. It has to be done under only by 342.
Lordship, the
Well,
question
it is recognized. It is recognized by the government of India, government of Nagaland, my lord. That is annexure, my lord, page 27.
No, not only that, whether it is given out there for that, the Scheduled Tribes Order.
My lord, that government has to, my lord, not party here. My lord.
Lordship,
That is
here,
normally also there in the available to everybody.
My lord.
Lordship,
But
the reason why the petitioner is raising this question is not disputing the policy of the state of Nagaland, but only to the limited extent that
Mr. Council, you have to get it from it is already, it is published everywhere.
yes, Lordship.
That the Scheduled Tribes Order. It's a presidential order.
Yes,
I
Lordship.
can't change it.
No,
It
Lordship.
is recognized there is recognized, matter over.
Yes, they are recognized. There's no dispute on that one, Lordship.
Then
But
matter is over.
the only question here is whether the policy of the state of Nagaland, without an adoption by the Gauhati High Court as per the rules or by the exception under section 229 by the Chief Justice, adoption by the High Court can apply the reservation policy of the state of Nagaland, Lordship. That is the only question here, Lordship.
Yeah, there is nothing specific to that effect. They are giving it to the Scheduled Tribe inhabitants in the state of Nagaland.
Out of the 6 posts, Lordship, out of the 6 posts, 4 has been reserved for general categories, Lordship. And 2 posts have been specifically reserved for Konyak and Phom tribe, Lordship.
Oh,
That is
see
further
the advertisement. See the advertisement. Where is it?
here, Lordship. Breakup of vacancies, Lordship, at page number 16.
No, page 47. We are concerned with that advertisement or which one?
no, advertisement, my lord, is page 16. my
Page
lord.
16, Lordship.
Page 16.
Page 16, the impugn advertisement is page 16, Lordship.
What did he say?
Breakup of vacancies, Lordship. Reserved for,
He has given example earlier. That is not the concern.
yes, Lordship. 4 has been reserved for indigenous inhabitants of Nagaland.
Serial number?
Serial number, close 1, Lordship.
Ah.
Close 1. 4 has been reserved for indigenous inhabitants of Nagaland. Reserved for Konyak tribe 1 post. Reserved for Phom tribe 1, Lordship.
Oh, how this is being done?
My lord.
How
That
is
is
this
why-
done?
That is the question, Lordship.
Why you are doing it only for the cognac or the Phom?
That is the
My lord,
question.
because of the policy, my lord, because of the policy, my lord, your lordship kindly say that is annexure E, my lord.
What is the policy? Page.
Page, my lord,
Page 27, Lordship.
page 27, my lord.
This is a government policy, Lordship.
So he is agreed by only these 2, my lord. He says that there is no adoption by the any high court, my lord,
and that is why it is illegal. Regarding entitlement, he is not, my lord. Silence, my lord. Konyak and from, my lord, they are entitled.
This is the reservation policy, but how does it, how do you only have it for Konyak and Phom?
My lord,
There are 6 tribes. Why only them?
Because, my lord, there is a requisition from your lordship kindly see, this is the resolution, my lord, discussing everything that is taken by this honorable court. So he is questioning that, my lord, that government policy has not been, my lord, adopted by the High Court. How he can, but because it is not within the power of 229(2). That is his argument, my lord.
What is PWBD?
That is physically handicapped.
Bench disability.
Bench disability. That is not unmarked, my lord. So it is no difference.
Now, where do I find that they are considered to be backward type? There shall be a separate roster for each different service, and each roster shall start with different tribes, so that the benefit of AI is equitably shared by the backward tribe. Example for the NCS. What is NCS?
Nagaland Civil Service, Lordship.
Civil Service. The Konyak tribe will open the roster, and Phom will open the NPS post, and so on. Now, what is his case?
His case is that, my lord, without any adoption by the government of Nagaland government, my lord, reservation policy, without any adoption, my lord, you advertise it. That is why, so far as these 2 person is concerned, that is wrong, my lord. That is his submission.
This is an adoption.
My lord, this is an adoption, and more so, my lord, in the case of Renu, they very clearly stated that you have to, that Renu, my lord, page 35, para 35, that policy of the reservation of the state has to be, my lord, and that is the in the domain of the power of the honorable Chief Justice, my lord, 229(2), and also, my lord, the act also residuary power. Your lordship kindly see, my lord, page 30, clause 36, my lord.
Where?
Sorry,
Paragraph
63.
35?
My lord, that para 35, my lord, 3 probably, last portion, my lord. His only grievance is that he is not no adoption.
Where does it say?
And also, my lord,
No, where in 35 it is said that the reservation policy will apply?
no, my lord, that adopt to the state policy has to be, my lord,
What?
last part.
State reservation policy is not mentioned.
State, my lord, last, my lord, I did not carry
Right.
it down.
Very. Anyway, let us
My
issue
lord.
notice.
My lord,
One thing, let us get to know. And Mr. Counsel, I think you may have to make the state a party.
my lord, state is, my lord, required, my lord.
Lordship, if I may just clarify on that, 5 minutes, Lordship. First, my case is that the state has a reservation policy, the state of Nagaland, no doubt, Lordship. There is, and the roster says that Konyak form accordingly, Lordship. There's no dispute on that. Now, the case herein is that without any provisions or rules to state that the state reservation policy will be automatically applied.
No, Mr. Counsel, it has not been done automatically.
Yes,
There is
Lord.
a administrative copy.
There has to be an obligation of my Lordship. Yes, there has to be a.
When it is done by the Chief Justice, it complies with 229(2). There's no quarrel with that. There's no problem with that.
Yes,
I'm
but-
not on that. But my only question is,
Yes, Lordship.
if we see the reservation policy, more particularly at serial number 7, page 28.
Yes, Lordship.
It states it is stated for NCS, it will start with NCS, it will start with cognac.
Yes.
And for NPS, it will start with foam.
Yes.
Now, but Mr. Mohanto, tell me, if that be so, why you have brought both of them together only for here?
Probably roster, probably they have sent it from the Nagaland bench, my lord.
No, it cannot be like that. They cannot.
But
Because
I have
if
to-
this is the policy,
My lord,
then you are the one post to, it's okay, you may start with cognac, but you cannot have the foam because what is the reason? Either it may be foam or cognac, but why you are having both?
both probably.
Anyways, there's always a dearth of the,
Yes. Equal
there is always a dearth of this employment out there in Nagaland. So you should not only stick to that. But why both?
Both, my lord, that was not this is pleaded case. That's why I'm not prepared.
No,
with that, my lord.
that is different. My court, pleading is not much necessary.
But he is not, his pleaded
Reserved
case is, my
for
lord, different.
backward tribe, first is cognac, then indigenous inhabitant of Nagaland indigenous, then reserved for foam. Now why foam? Or you could have been foam.
Then Konyak is out.
Somebody has to be out because you cannot adopt, because there it says that for NCS it is foam, cognac, and for NPS it is foam. It will start for reservation. So therefore, why both of them are being put? Why we are merging NCS and MPS together? Well, there has to be a justification. It cannot be a mechanical exercise by the High Court. I think it's a good case for stay. Good case.
No, my lord, that was not his pleaded case, my lord. That's why, my
Not
lord.
necessary. He will improve his pleadings. Are you not?
Yes, Lordship.
How can I answer, my lord? He's right.
No, not you. I'm saying here.
My lord.
He is here. Na. He'll improve it. Whether you are going to improve or not.
Yes, Lordship. But Lordship, the
Your point which you are saying
Yes, Lordship.
would not hold much water. Because what has happened, they have adopted it. But the fact remains, why they may very well say this reservation of foam cognac is one. But what about the other one? Now let us see the advertisement.
Page 16, Lordship.
No. You have to develop the reserve for indigenous 4, reserve for cognac tribe 1, reserve for foam 1. Because they are backward classes.
Yes, Lordship. There's no dispute on that one, Lordship, as identified by the state of Nagaland, Lordship. Now, this is the first time this reservation has been given in the Gauhati High Court Kohima bench, Lordship.
Not first time, my lord.
And earlier to that,
Yes, Lordship.
one has also to see, have you maintained a list as to form and cognac as per the policy? Because this policy is of 2011.
Yes, 2011, my lord.
So have you maintained any policy to that effect?
But I
That
have-
look here, that these are the roster points which we are fixing
Probably
out.
that is taken into account.
If
in my
there
lord.
are already form out there,
My lord, then
how will the roster point will apply?
probably that was, my lord, discussed in the, my lord, but minutes of the meeting, my lord. Probably
Huh?
all out, not me, my lord.
Lordship, if I may take to page 43, Lordship, I have annexed one
So,
advertisement of 2019, Lordship.
Hmm.
Here, 2 posts of judicial assistant are being advertised, Lordship. And here also no reservation, Lordship, of specific,
Huh?
Lordship.
There is no?
43, Lordship.
No, there is no reservation. There also, again in 47 also.
Yes, Lordship.
There is no reservation.
Yes, Lordship.
But if there is no reservation, only the question is, if you are having it, but if there are already form and here, how do you take care of it?
government,
This is on the case this is a case something like they are already scheduled tribes,
already seen it.
but there is a reservation within the reservation.
Within
This is something like the Davinder Singh's judgment.
judgment. Konyak and my lord, Shum,
So you are saying that one person will be there from there and there.
my lord. So how did roster is maintained, my lord? That has to be shown. We have to go through the record, my lord. Probably that was placed before the honorable, my lord, that appointment committee, my lord.
But the application has already, the people have done it. Now what has happened? Why are you so late?
We are waiting for the last 2-3 months, my lord. That advertisement is of my lord.
Why so late? Who are you?
The petitioner also submitted representation to that effect on 20,
And that was rejected, man.
2026.
No, it's okay. The representation submission would not help anything. But my question is why you have come so late?
Lordship,
The results are to be announced.
No,
no, Lordship. Examination has not yet been conducted, Lordship.
Oh, let it be done. Let us issue notice. In the meantime, you make him a party. No stay. Issue notice making it returnable on Nagaland, when it is the division bench day? Wednesday, na?
Yes, Lordship.
Wednesday?
Yes, Lordship.
Okay. On 22nd of 22nd of September 2026.
Lordship, the
24th of September.
one submission, Lordship. The
Yes.
written examination is to be held on 12th, Lordship, of September,
Oh.
Lord.
Very good. Let us also know the result by then.
No, Lordship, if I have a prayer to that extent, at least till the next available date, Lordship.
No.
That advertisement, that notification.
24th of September. Okay, 17th of September 2026. Mr. TJ, your junior, so and so accepts notice on behalf of respondent numbers 1 and 2.
May I please, your lordship?
So and so accepts notice on behalf of the respondent number 3.
Lordship.
Extra copies of the writ petition be served upon them by tomorrow. The petitioner herein have assailed the advertisement dated 19/5/2026. You are which tribe?
Sumi tribe, Lordship.
Petitioner herein who belongs to the Sumi tribe has challenged the advertisement dated 19th of May 2026, primarily on the ground that the said advertisement could not have been issued by the respondent number 3 without the adoption of the government adoption of the notification dated 14/4/2011 of the government of Nagaland by the Chief Justice under Article 229 of the Constitution. This court had Mr. T.J. Mohanto, the learned senior counsel, who is also the standing counsel of the Gauhati High Court during the course of the hearing, admitted that prior to the notification being issued on 19th of May 2026, the Gauhati High Court on the administrative side have granted the approval by adopting the roster points as mentioned in the notification dated 14/4/2011. This court have also taken note of that though the advertisement was issued as far back as on 19/5/2026, the petitioner has approached this court
27 August.
24, correct?
Filed on 24.
on 24/8/2026. Under such circumstances, this court is not inclined to pass any interim directions without giving the respondents an opportunity to place their case. The respondents are directed to bring on record their stand by filing the affidavits on or before 14th of September 2026. So it is further observed that Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that a written examination is on 12th of September.
Yes, Lordship.
It is observed that any appointment so made on the basis of any selection or appointment made on the basis of the impugned advertisement dated 19/5/2026 shall be subject to the outcome of the writ petition.
Obliged, Lord.
Yes, Mr. Ahmed.
Our paternal land has been forcefully taken away.
Huh?
Our paternal land has been forcefully taken away. They take a position
By?
by the DGMC authority.
It?
Yes, madam.
Lordship, my
And,
take up my
more is-
affidavit. Lordship will take up my affidavit, my lord.
Okay, let us take care of it. What do you say?
If Lordship comes to affidavit, my lord, this particular piece, parcel of land of 52 bighas, my lord, around
Huh?
52 bighas. If Lordship turns to assigning page number 81 for the
Yes.
municipality disposal
Certificate of handing over and taking over.
by
Yeah.
from GMDA to GMC, my lord. This is the parcel of land handed over, my lord.
Handed over by?
GMDA, my lord. Lordship will see in the top. So and so,
GMDA
Chief Executive Officer,
handing over
GMDA,
to GMC.
Second Row Commission, GMC, for establishing the municipal disposal waste. And that area has been taken up by the GMC, and that project is going on. And allegation is that the
And what
petitioner's
is the
land is
case
taken.
of the petitioner?
We are the patta holder, my lord. We are the patta holder, made the patta land. Then, my lord, they have suddenly they taken our land used for garbage, store of the garbage, my lord. Then
You are the owner of which land?
owner of land, my lord, I mentioned Patta number, duck number 1788 or patta number 806.
This is your land.
Yes, my lord. And
These, but this certificate of handing over and taking over is given by the GMDA to you. But is the GMDA the revenue authority?
It was the GMD's land.
Understood. So you have to bring somehow the GMDA's title over the land.
My lord.
This type of affidavit would not do.
GMDA was implemented later on, my lordship. Then lordship will give me liberty to file an affidavit from the
You are also GMDA council.
my lord.
Okay.
paragraph 8, my lord, the lordship will their affidavit. Paragraph 8, my lord.
Huh?
Paragraph 8 of their affidavit, my lord.
What do they say?
The lordship can be seen.
That question, my lord. It was handed over on 16/3/23,
Now-
my lord.
Now, this would not help you.
And then, my lord, affidavit filed by.
No, I think the affidavit has to be filed by the
Circle officer.
government.
Yes, sir.
Government is in.
The paragraph 4, 5.
You are not filing an affidavit. What do you say?
Paragraph 4 and 5.
Wait.
Page 85.
Mr. J. Ahmed seems to be very excited.
Page 85, my lord.
Anyways, tell me, what is your affidavit? What do you say in your affidavit?
Lordship, regarding the plot of land which is mentioned by the writ petitioners is belong to it's an Azmali Patta in the name of the petitioners. That it is reflected in paragraph 4.
4 and 5.
Affidavit
Paragraph 4 filed by the respondent number 2 and 3, page number 86. This 24 bigas 3 kathas 12 and half lectures covered by DAG number 1718, 1772, 1773,
What is the
1774.
petitioner name?
Hasmut Ali, number 1.
Asmat Ali. So he is one of the owners.
Yes.
Yes.
And number 1, Sophia, paragraph 5.
Owner
Sophia,
is the owner of various DAGs.
Yes.
and so 1 Sophia Khatun, president number, he's also passes land.
So if that is so, and this particular land falls in this,
Yes, Lordship. That is paragraph 5.
state there no comments to acquire and purchasing animal further.
Paragraph 7, Lordship, we have
7.
categorical.
Paragraph 7.
The land measuring park.
Paragraph 7, page 87.
Yeah?
Paragraph 7, Lordship. During the field verification, it was observed that over the land covered by DAG number 1788 of KP Patta number 806 of the
Ah.
the Gauhati Municipal Corporation is operating a project for urban solid waste management and centralized disposal facilities for Gauhati.
Now we'll page 68 of my writ petition, my lord.
Yes, that is why I say this type GMDA and GMC council is also same, everything is same. So therefore we cannot trust them. My question is, you have to.
This is old DAG number 776.
What's all, they know, they categorically say 1788 of KP Patta number
Yes.
806 is where you are having the solid waste and it belongs to them. Matter over. Are you going to acquire or hand over? Either of you.
Page 68.
DC.
Mister,
For
Mr. Ahmed, I know what it is. Wait. Yes. What do you want to do?
Done by the deputy commissioner.
But the proposal shall have to be come from their side.
Why will the deputy commissioner ask you? My goodness. Oh, is the deputy commissioner the requiring authority or you are the requiring authority?
Then that process will start. In fact, the process was.
And this has to be further subject to once the deputy you require and give it to the deputy commissioner gives the assessment.
Lordship.
Then upon the deposit has to be made,
Yes.
then only, because I know the GMC, they will say that the government has not provided fund.
This is the process.
Although that department also he appears, ZDD.
For a moment, page 68 to last second. Just a moment, well. Page 68,
Anyway,
my.
no, I am satisfied with you. Now the question is, if you want to run, yeah, or otherwise we stop it.
We want to run. This is the We want to
Use
run
the
that-
mic.
No,
Yes.
we have to run that particular process. Ultimately.
No, if you run or don't run, that is your lookout. Where you run, it is different thing. Nowadays, the government is vacating many lands of many people. Take those lands. Why you are after the petitioner?
Lots will post it after 2 weeks, my lord. In the meantime, I will get the
Instruction.
instruction.
The grievance of the petitioner in the present petition is that the GMC authorities is operating a project for urban solid waste management and centralized disposal facilities within the land belonging to the petitioners. Though in the affidavit filed by the respondent number 4 and 5, it is being submitted, it is mentioned that the said land was handed over in the year 2023 by the GMDA to the GMC. But from a perusal of the affidavit filed by the
Number 2 and 3.
respondent numbers 2 and 3, it is apparently clear that the petitioners herein are the owners of how many petitioners?
Two petitioners here.
The petitioners herein are the co-owners of various plots of land at measuring 324 bigha, 3 katha, 12.50 lechas, which includes amongst various dags, dag number 1788 of KP Patra number 806 of village Pachim Boragaon under Jalukbari Moja. It is also mentioned at paragraph number 7 that in the said land at dag number 1788 of KP Patra number 806, the Gauhati Municipal Corporation is operating a project for urban solid waste management and centralized disposal facilities. So taking into account the stand which has been taken by the revenue authorities, it is the opinion of this court that either the respondents in the GMC as well as GMC enters into some form of a settlement with the petitioners or acquires the land in accordance with law. So without that, the GMC authority, which is the GMC, which is a state, cannot be permitted to usurp the lands of the petitioner, of the land of the petitioner. So list this matter again on 5th of October 2026. In the meantime, Mr. Asbora appearing on behalf of both the GMC and the GMDA. You are also GDD party?
Yes, sir. Department of Housing and Urban Affairs.
Appearing on behalf of the various respondents, including the GMC and the GMDA, shall obtain the necessary instructions and apply this court.
At 2, my lord.
By 2. First, let us get your instruction.
My lord, they are paying rent to other persons, madam.
Yeah. I have stopped giving at too many councils. One is Mr. B. Gogoi, the other is Mr. D. Nath. They have lost their chances. Anyways. Yes, Mr. S.B. Chaudhary.
In this case, the affidavit has been filed with regard to the fact that this the contention of the petitioners where this amount has not been released. At the same time, certain notices have been issued for this vacating the land, concerned land, which has been acquired. Now, I have taken the instruction, Lordship, this although they are saying that this hearing already taken place and they are going to release the amount, but no amount has been paid till now, Lordship.
Here.
Allah,
Yeah,
you have deposited the money?
Yes, under TS1 we have already deposited, but here issue is not that one, my lord. Issue is this petition is challenging the TE notification. TE notification, that taking grounds of that, taking grounds, paragraph 6 of the petition is mentioned that due to pendency of this one. Here, my lord, we have after depositing the amount, 3D declaration, 3G, TS1 we have deposited. There are disputes among the parties. That is why this one, even it has gone to our division bench also. Lastly, it was sent to principal judge.
No, dispute with regard to the
No,
Jirat amount,
let
Lordship,
me-
not with regard to the land.
Let it be. This is Jidat or this one. This is a compensation under TG. Whatever amount, my lord, that is pending now. Decision is pending before the principal judge. Principal judge, it has been referred to principal judge. Now our question, putting myself question, my lord, that whether for disputing this our possession is not given or we cannot go for construction, this is public money.
No. You immediately take over possession.
Yes, that is our stand. That is why amount already deposited there, own dispute, it is not been paid. It is not fault
There
on
is
of the way NSCI
Lordship,
or
all the legal heirs in the affidavit, they have said that the legal heirs, they have submitted the affidavit clarifying the stand, that there is no dispute with regard to the apportionment of the amount. But even after that particular affidavit has been filed, no hearing taken place and no amount has been.
Why the matter is pending before the reference court?
No, it has not been referred, Lordship.
my
It
lord.
has not been referred
My
because
lord.
what has happened, let me submit, Lordship. Here in this case, on the last occasion, before this honorable court, the matter was taken up with regard to the Jirat amount. That particular writ petition has been disposed of. Now, this writ petition, when it has been disposed of, there is a specific direction for referring it to the reference court. But till date, it has not been referred to the any court, Lordship. These petitioners are running from pillar to post with regard to that.
Wait.
Necessary affidavit has been filed from the their side. The money will be disbursed within a week. Just now I have spoken to the concerned officer.
I am asking you whether the amount has been disbursed to you,
Yes, madam.
whether there is an objection.
Everything is in one while
My
speaking.
question, Mr. Das, kindly listen. Whether there is an objection,
Everything has been clear. Till now, no objection, madam.
then decide under 3H3. No objection, make the payment.
Yes,
If
sir.
there is an objection,
Yes.
There is the thing, Lordship.
Finish.
Yes, we are just praying for the release of the amount, Lordship.
Yes, madam. We are ready. Within a week, my lord.
My humble prayer only last line.
It's a disposal
Because,
matter.
we may be allowed to go for construction, my lord. Only-
finishing it off. I'm allowing it.
Yes, that
Yes.
is. That is
What
our
else do you require?
Yes, it is required, my lord.
Take your seat. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. Petitioners. Mr. who appears for revenue? He appears. And does appears for response number 234. Mr. C. Borba appears for response number 5 and 6. 5 and 6.
My lord.
The present writ petition has been filed by the petitioner, being agreed by the non-release of the compensation relating to the land covered by DAG number 141 oblique patta number 81. Circle Boko Revenue Circle. And what is this order of 9-6? What order you are challenging 9-6?
9-6, Lordship, this notice as issued with regard to the vacating the land, Lordship.
As well as the notice dated 9-6-2026, whereby the respondent number 3 have directed the petitioners to vacate the land. It is a submission of Mr. S.P. Chaudhary, the learned counsel, appearing on behalf of the petitioner, that there is no dispute as regards on the questions of entitlement and or the apportionment of the compensation. And therefore, the competent authority ought to disburse the said amount of compensation in respect to the lands in question. This court have also heard Mr. C. Borua, the learned counsel, appearing on behalf of the petitioner, respondent number 5 and 6, who submitted that the amount of compensation have already been disbursed to the competent authority of land acquisition. Mr. N. Das, the learned counsel, who appears on behalf of the respondent number 2 to 4, and more particularly respond number 3, who is the competent authority of land acquisition, submits on instructions that the amount have been deposited by the central government in terms with section 3H1. This court finds it pertinent to take note of this upon a notification issued under section 3D of the Act of 1956. The land in question vests with the state, will vest with upon the central government. Under such circumstances, the non-release of the compensation cannot be a ground for not vacating the land in question. Under such circumstances, the question of interference with the notice dated 9/6/2026 does not arise. Insofar as the question of non-payment of compensation is concerned, Section 3H of the Act of 1956 duly provides 3H of the Act of 1956 is a standalone provision, is a provision by which the payment of compensation is made, is disbursed. And in the case of disputes of complex nature pertaining to entitlement of the compensation or the apportionment of the compensation, it is the principal civil court of ordinary jurisdiction within whose jurisdiction the land is acquired has to decide. It is also very pertinent to mention that the mandate of section 3H3 makes it very clear, of the Act of 1956 makes it very clear, that there is a duty reposed upon the competent authority of land acquisition to disburse the compensation unless a dispute of complex nature arises on the question of entitlement and or apportionment of the compensation.
My lord, in this case, my lord, there is a conflict arise. That's why it could not be finalized, and ultimately on my lord, 10/8 a hearing took place, and all the claimants have, let me say,
wait.
Ultimately on 10/8, my lord, all the hearing took place, and all other complainants and my lord have filed their affidavits in this regards. And my instruction is, my lord, within a week, it will be disbursed to the claimants, my lord. The amount. Within a week, the money will be disbursed to the claimants, my lord. Process is going on. Earlier, we couldn't be finalized due to there are multiple conflicts between the claimants, my lord.
My instruction is that with regard to land, there is no conflict because the land belongs to all lordship. Only the Jirat amount, there is a conflict and it has already been sorted out. He's making some.
In this regard, this court finds it pertinent to take note of the judgment of the Supreme Court in the case of K. Venkateswamy versus so-and-so reported in so-and-so. And paragraph number 22.1 to 22.7 is reproduced here in under. Taking into account the above proposition of law, it is the opinion of this court that if the petition, there is no dispute as regards entitlement and or apportionment of the compensation, which is complex in nature, the competent authority of land acquisition can resolve such dispute and make due payment, disburse the payment to the entitled. Accordingly, the instant writ petition stands disposed of with the following observations and directions. Number one, the challenge to the notice dated 9/6/2026 issued by the respondent number 4 is thence rejected for the reasons aforementioned. Number 2, the respondent number 3, who is the competent authority of land acquisition, shall forthwith disburse the amount subject to there being no complex disputes pertaining to entitlement and or apportionment of the compensation. Number 3, if there are disputes of complex natures, the respondent number 3 shall forthwith and not later than 15 days from the date a certified copy of this order is served upon him, refer the dispute to. Where is this?
Amingaon, my lord.
Amingaon.
To the learned court of the district judge, Kamrup Rural. Immediately thereupon, the amount which is payable on account of the compensation shall also be disbursed to the learned court of the district judge, Kamrup Rural. The district judge, Kamrup Rural, shall decide such disputes in accordance with within the contours of sections 3H4 of the Act of 1956, and thereupon disburse the amount to the entitled as per its opinion.
Lordship, 2 points only. With regard to the description of the land, other lands are also there. It is there in paragraph number 3, Lordship. 140 and other lands are there. So this some mention is required, Lordship, because only 141 has been mentioned. With regard to other lands also 140, 99, 261, all these lands are also.
Yep, in your prayer you have mentioned many ducks.
Yes, Lordship.
All these ducks are there.
Yes.
That will be inserted. In your prayer you have mentioned 4 or 5 lands.
Yes.
So all these things are mentioned.
And whether the amount can be released within a stipulated period of time, Lordship, because otherwise it will.
I said forthwith.
15 days.
15 days the amount is to be released because the
I said forthwith.
Forthwith.
And if it is not done within 15 days to make a reference.
Yes.
Well, the stay order passed earlier, 26/6/2026. Maybe.
What?
Stay order
The
is
same
there.
orders passed earlier stands vacate.
My lord. Obliged. One again.
Yes, the council with the longest name. Tell me. Tell me, what is it? Reserve Bank. What have you done with the Reserve Bank? Oh, that one. Yes.
Yes, Lord. Lordship, if your Lordship may kindly take up my additional affidavit, your Lordship.
We'll take this matter some other day. This will require further more deliberation
Lordship.
on the question of these. Because I remember the case in detail. Here I have put you 2 questions and
Lordship,
you don't have a
yes.
satisfactory answer.
Yes, Lordship.
That is the answer. But the only thing is what course of action has to be taken in view of your non-satisfactory answer.
Lordship.
There is two ways to look into it. One is we set aside that is one aspect, but that doesn't say, should I remand it back by giving him an opportunity and thereupon, because his specific question is out here. Then look here, without giving me a notice, what you have done is you have written some letters to the RBI and all.
In fact, the last notification of RBI, it says that opportunity to be heard.
Your Lordship,
Therefore, the opportunity has to be granted, so that needs to be set aside. And giving an opportunity to him, you decide and finish it off. Your Axis Bank.
Lordship.
I remember. We do one thing, we have it on. Wait, I have my place next month. Let us see.
But one thing is that, my lord, because of fraud reporting, my lord, for last 2 years, my lord, petitioner is not getting any job anywhere, my lord. Because he is a believer, my lord, and he's suffering, my lord, for last 2 years, my lord. And my lord, last occasion I have filed an affidavit, my lord, annexing the latest circular, my lord, master circular.
~31st, it's open, huh?
Yes, ma'am. Yes.
Oh, we have it on 31st. It's a blank. No, actually, it has not caught my attention in this year. We have it on 31st, Monday. Is the matter on Monday at the top of the list for disposal? Oh, this means which the 31st is a blank thing. Okay.
My lord, in item 58, I have mentioned in the morning, my lord. I have filed an impleading petition today, my lord.
Okay. Where is this? Am I taking 58?
Yes, sir.
Okay. What is this? Mr. Goswami, what is your matter?
That compensation of the land acquisition, my lord, paragraph 4 of the government.
He has filed in some application for impleadment.
My lord, that
I have not given the copy of
the
that. my lord.
copy, my lord, my learned friend has refused to accept in the first
Because-
time.
How can you refuse at this
It
age?
just come now, my lord. In the first half, I was not in the court.
Anyways, you give him a copy. We
Right
have
now.
it along with the interlocutory application. Mr. P. Hazarika, the learned counsel, submits that an application has been filed by him on behalf of his has been
number,
filed by certain applicants seeking impleadment, seeking an appropriate direction from this court to be arrayed as parties to the instant writ petition. He submits that the said application is not on record. So accordingly, list this matter on 9th of September 2026. The registry shall bring on record the said application.
I have furnished the copy.
All right, sir.
Very pleased, Lordship. Lordship,
Yes.
sorry, Lordship.
What is this case?
Lordship, case, Lordship.
Why you are not before the Assam Board of Revenue?
Yes,
Why you are here? Your order has been cancelled by the ADC.
The additional
ADC.
deputy, sir.
Why you not filed an appeal before the Assam Board of Revenue? Go there. Not here.
Should here also, Lordship, kindly give some relief. Otherwise,
What?
some relief. Otherwise, Lordship, that additional the DC Lordship, he can, Lordship, hear the matter again, Lordship. Because
Absolutely no.
why I'm saying, because
No. You go and file an appeal. I will give you the limitation for that. These type of cases cannot happen. The Assam Board of Revenue otherwise doing no work because of you. You're coming here. Let them do some work.
the limitation of access.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. B.J. Talukdar, the learned Senior counsel assisted by so-and-so appearing on behalf of the respondent number 2, 3, 4, 5. So-and-so respondent. Yeah, full stop. The present petition has been filed by the petitioners assailing an order passed by the learned ADC, Borpeta, dated 4/12/2025, whereby the mutation order, mutation of the petition, whereby the names, whereby the mutation granted in favor of the petitioner was cancelled. It is the opinion of this court that an appeal lies to the Learned Assam Board of Revenue in terms of section 147?
47, 147.
A only of the Assam Land and Revenue Regulation 1886 against an order passed by the Deputy Commissioner or his assistant Deputy Commissioner. Considering the above, as the petitioner has an effective and alternative remedy, it is the opinion of this court that the petitioner should be relegated to the Assam Board of Revenue for filing an appeal against the order dated 4/12/2025. This court also takes note of that it is also very pertinent to observe that as this court have relegated the petitioner to the Assam Board of Revenue, and apparently the period of filing the appeal is over. An opportunity has to be granted to the petitioners to file the appeal. So accordingly, this court directs that if the petitioner files the appeal within a period of 30 days from today, the Learned Assam Board of Revenue shall entertain the said appeal without insisting on the period of limitation.
Oh, Lordship, order of date, Lordship would be 26. Lordship.
Same orders passed
Date
earlier.
date of order, Lordship.
Probably it was 26.
Yes, Lordship. Date of order is 26, Lordship.
Huh?
Date of impugn order is 26, Lordship.
The order is not 4.
No.
Yes, Lordship. It is the main order date is page 41, Lordship. Maybe seen.
Page
41.
It is 41.
4/12. No, 26.
Serial number and date of order.
26/12. 26/12. But then also you have a problem with the limitation. It's 90 days.
Lordship, just
26/12.
May it please.
Yes. What does it?
That's it's a short review, Malats, of paragraph 139(12), if your lordships recall, Malat. And I'm before your lordships, Malats, pursuant to the order of the division bench of 18th August 2026, if your lordships have, Malat, at page 222. Page 222, if your lordships have, Malats.
Yes.
All this, and Malats, we had filed a limited writ appeal, Malats, to the extent of, Malats, the findings of your lordships at paragraph 139(12), Malats, where your lordship said, Malats, that the petitioners having given up their plea with regard to, Malats, the challenge on parallel proceedings are debarred, Malats, in future from raising the plea. Now, Malats, if your lordships have the third paragraph, these appeals have been preferred by the appellants on being aggrieved with one specific direction in paragraph 139(12) of the judgment dated so-and-so passed by the learned single judge of this court in a batch of analogous writ petition. By the aforenoted judgment, a batch of writ petitions were disposed of. The grievance of the appellants lies in a very narrow compass. While deciding and concluding the case largely in favor of the appellants, writ petitioners, it was recorded that since the appellant writ petitioners had given up their plea regarding the legality of continuing with the disciplinary proceedings parallelly to the pending criminal proceedings, perhaps on the same set of facts, the appellant writ petitioner would be debarred from raising such contention in the future. In all these appeals, the challenge is only to the aforementioned aspect, namely the direction debarring the appellant writ petitioners on the ground that it is not only unwarranted, but also not in accordance with law and is violative of the fundamental rights of the appellant regarding access to justice. The learned counsel for the appellant in this set of appeals have argued the point in question was definitely given up by them during the course of arguments, but it was only for the time being when the matter was being heard, without expecting that such a concession for the purpose of those cases would lead to the permanent debarment from taking the plea even in future. It has been argued that such a debarment legally flawed. The Lordship feels. However, in our considered view, we find that it would be more appropriate if the appellants approach the learned single judge under review jurisdiction for giving a relook at the matter, which whether the concession made of a particular at a particular time would justify their complete debarment from raising such a plea. Mr. Kohli, learned senior counsel appearing for, has agreed to such a view taken by this court. We therefore permit the appellants to withdraw these appeals in order to enable them to prefer the review petitions before the learned single judge. Since the matter is urgent, we request the learned single judge to take up the matters at the earliest and pass necessary order. We order accordingly. All these appeals stands disposed of as withdrawn, enabling the appellants to prefer respective review in case so deemed necessary. Now, my lords, your lordships, finding, my lords, at paragraph 139.12 is at page 205. And before that, my lords, I must place, my lords, page 101, paragraph 3 to 6, where your lordships recorded, my lords, at the outset, your lordships recall, my lords, there were two sets of petitions, my lords. One was a set of petitions where Mr. K.N. Chaudhary was appearing, my lords, where the issue of parallel proceedings was raised. Lordships, see at page 101. At the outset, it is relevant to take note that in some of the writ petitions, a contention has been asked questioning upon the legality and validity of the continuation of departmental proceedings, pending criminal proceedings. Mr. K.N. Chaudhary, learned senior counsel, along with other counsels for the writ petitioner, submitted that the writ petitions where they are representing, their writ petitions should be restricted only to the question of the legality and validity of the reports submitted by the one-man commission, and whether on the basis of the said reports, the departmental proceedings against them can be initiated.
Well, at that point of time, when I was taking up the matter, I was against this
Parallel proceedings.
proceedings. And therefore, you along with all the other councils have taken up plea that why should we raise this?
No, my lords.
And Mr. Counsel, let me make it very clear. Either the division bench ought to have decided, but my question is, the division bench cannot restrict this court to the review.
Yes, my lords.
If the division bench does, because my fundamental manner in which I take up a review is to recall the first judgment.
Yes, my lord.
We'll recall the judgment and thereupon we'll again hear.
Yes, my lords. No, my lord, my respectful submission on this is that, my lords, that your lordships, my lords, ultimately, my lords,
I cannot. I will have to recall the
I
judgment.
will satisfy your lordships on that, my lords. As the 226 court, my lords, your lordships have the plenary power, my lords, irrespective of the civil procedure code. We keeping the civil procedure code order 47 aside. Your lordships has the plenary power, my lords, as a 226 court to recall, review, or even, my lords, to that extent, my lords, delete any findings if your lordships feel.
Mr. Kohli, I don't think that you mind I recalling the judgment.
Lordship, there may be an issue with that because we have, Lordship, gone ahead and implemented the judgment, Lordship. In fact, Lordship may just bear with me for a minute. There were two sets of counsels. I mean,
The
Mr.
judgment of the Supreme Court which says that once the judgment has been put to implementation, there cannot be a review.
Which is why, Lordship, I'm saying that there is an issue here. Not only that, Lordship, respectfully, this was a case of concession.
So
He has
therefore,
exercised the
I
doctrine of
can do
election.
only one thing. I can only do one thing is to recall the judgment. I can't review
Lord-
it, but I have to recall the judgment, the entire thing.
Mm,
And thereby the
uh,
entire thing comes over.
Lordship, if that is recalled, we have already gone ahead, issued the fresh show cause notices, and there is a movement on the disciplinary proceedings. Secondly, Lordship, respectfully, just Lordship, I am assisting Lordship. And with the judgments that are there, line of judgments say that once a court of record, which means once Lordship has held something, it has to be finally looked at only by Lordship, either through a review or a clarification. Perhaps Lordship, subject to what Lordship feels, my learned friend could consider clarification, because a review at this stage, Lordship, when the judgment is implemented, may be an issue, Lordship.
Not possible review.
That's may I just satisfy your lordships on this? Well, this paragraph 139.12 is not something which the state has to implement. 139.12, my lords, is a direction from your lordships, stating, my lords, that debarring the petitioners before your lordships, who were part of those writ petitions, from raising this plea, my lords, in future in any proceedings. Right, my lords? Now, what has happened is, acting on your lordship's judgment, your lordships, my lords, allowed them the liberty that if they so desire, they can de novo initiate proceedings. So, my lords, they withdrew their earlier so-called notices of 30th November 2023, which was the subject matter of challenge before your lordship. My cause of action, my lords, in those writs were the suspension order and the so-called notice of 30th November 2023, and the findings, recommendations of the one-man commission report.
And how can only one person's review we can take it?
No, my lords,
There are so many petitioners.
ultimately everybody is there, my lords. The
Not
point
there.
is, my lords, immediately.
Because I will, if I recall the judgment for one, then it will affect the others.
Ultimately, just for positive, because what has happened is this.
This cannot
On
happen.
8th May 2026,
It's an order unless all the persons come in.
all I cannot, my lord, I am appearing for the person who has instructed me, my lord, who has briefed me. Now, my lords, the case is this, my lords. Today, pursuant to your lordship's order, on 8th May 2026, the departmental proceedings initiated earlier was recalled, dropped rather, and fresh departmental proceeding is initiated. Now, my lords, in that departmental proceedings, that is entirely premised on the special investigation team investigation, where, my lords, my client is my lords, before the trial court. Right, my lords? So, my lords, that so-called notice, the proceedings initiated, my lords, impacts me, because if I have to go ahead with those proceedings, my lords, I may have to disclose my defense, which otherwise, my lords, is my defense in the trial court. Similar witnesses, all the witnesses, my lord, including the investigating officers in the charge sheet number 14, are now made witnesses in, my lord, the departmental proceeding. Law permits me, my lords, that in case the facts are so intertwined between the departmental proceedings and the criminal trial which is ongoing, and, my lords, if it involves complex issues, and if, my lords, while defending myself in the departmental proceedings, I tend to disclose my defense, which my defense will be before the criminal trial, my lords, then, my lords, there are judgments where the courts have said, the law, my lord, is that in that case, my lords, the departmental proceedings can be interdicted. Not, my lords, for all times to come, can be interdicted to see that the person facing the trial
So the
is not.
criminal trial will take ages.
That step will arise, my lords, once we challenge this. Now, my lords, my cause of action.
Guys, no, this cannot happen, because that was the point on which I was taking it up, and I said that I am not satisfied with this point of parallel proceedings.
Yes.
And thereby, at that point of time, the councils left it.
No, my lords, if your lordships recall, my lord, there were two batches. One batch where I was appearing. my lord.
Whatever may be.
Our
the-
case,
the
my lord, was.
second batch is, the question is, you are debarred by constructive res judicata.
It may be, but my lord, on what? On the same cause of action.
Anyways, today will let us issue notice on the, what do you call this application for condonation.
My lords, this is a technical delay.
This Lordship on point.
No, there
18th
is,
18th
I have
is
to
the
issue
judgment.
notice. Can I condone the delay in a review petition like this?
My lord, I was pursuing my proceedings before the
what?
division bench. 18th is the order. 20th.
First of all, you see the division bench making it, the division bench can't remand the matter out here or ask this court to exercise the review jurisdiction on a limited sphere. The division
be,
bench power
Malas.
is limited. It can very well say out here to the effect, because you see, yes, the division bench can remand the matter or ask the court to look into it, asking you to file a review petition, whatever may be.
Yes.
But the review petition's power cannot be confined by the division bench to say that, like, kindly look into
No, my
it
lords,
only in this
my
respect.
respectful submission is this, my lord.
I don't agree.
My lords,
with that.
in the hierarchy of courts, my lords, the division bench has, my lords, restricted me, my lords, and said that you go before the single judge. In our opinion, you go before the single judge and raise this issue only to that extent, which, if a lordship see, my lord, at page 223, whether the review jurisdiction for giving a relook at the matter, whether the concession made at a particular time would justify the complete.
I am very particular. Whenever the review was, There was one judgment before. I passed an order out there. The division bench said that for this court to look into it. I said I won't take up the matter.
That's
Let
your
it go
lordship's
before any other
prerogative, my
court.
lords. But what I'm saying is this, my lords.
I'll do one thing. Let it go before any other court.
No, no,
I'm
no, no,
not
no,
going
no,
to-
that-
no.
no, no, my lords.
I'm not going to do that.
I'm not saying this, my lords.
I'm
No,
not going to do this.
no, no, your lordship will
Because
deal.
the division bench order has to be more respective. It cannot pass an order directing the single judge out here.
In fact, my
Say
lords,
that you only look into this aspect.
In fact, my
Make
lords,
it very clear.
the division
Very
bench, my lords, was
pertinent
not.
on this aspect. The division bench cannot pass that order.
My lords, the division bench said, my lords, in fact, to me, my lord, when I was arguing, addressing, that
That's
you
a
go before
different
the
thing. The division bench could have very well dismissed the appeal or allowed the appeal. I'm nothing to do with that. That is a different aspect of the matter. But the division bench cannot restrict the jurisdiction of this court.
No, my lords,
As I say, I have the plenary powers out here to exercise.
yes, as a
And
226
this
court,
power cannot be restricted. by the
226
division
court, my
bench.
lords, your lordship has the plenary power.
Our jurisdiction of the division bench is only to look into it as to whether the division bench, my order is so perverse enough that the division bench would like to interfere. That's the only jurisdiction the
ma'am.
division
Yes.
bench has.
Yes.
It is therefore said to be an intra-court appeal, not an appeal in
Yes,
statutory
it's
appeal.
inter-court appeal, my lord. But
So therefore, the division bench jurisdiction, the exercise of jurisdiction which I am doing is exactly the same jurisdiction the division bench is doing. The division bench cannot ask me to do a particular thing.
But my lords, I can't say anything on this, my lords. My only submission is, my lords, in a hierarchy of courts, my lords, when the division bench, my lords, has my lords, in fact, told.
I can give you 2-3 judgments out here where the Supreme Court had frowned upon the division bench when it has been remanded to the single bench to look into it.
My lords,
Because the Supreme Court categorically mentions out there the division bench do not have the power to remand a matter back to the single bench unless it is a case where the single bench had disposed of the matter without giving the respondents an opportunity to file the reply. And without that, and
No, no,
at
my
that point of time, when the division bench was looking into it, yes, thought that a reply of the respondents were required, and therefore, in order to do so, the filing of the affidavit has been permitted out here.
yes, ma'am.
That's the only.
No, my lords,
jurisdiction
my challenge before the division bench was only 139-12. And the division bench, my lords, relegated me to your lordships, my lords, directing that only this issue be raised before the honorable single judge.
So that
for a
is the
recon-
issue you have raised.
Yes,
You-
my appeal was
so there-
limited.
There couldn't have been any other grievance.
Yes, yes, my appeal was limited.
So therefore, the appeal, the entire thing, if I have to do it, I'll have to recall the judgment.
No, no, my lords, that is
And
not required. I will,
the judgment would affect the other sides,
no, I'll satisfy.
other parties. So
I will
without the
satisfy-
other parties being brought on record, who were petitioners out there, who have got the judgment out there, how can I recall one? Because it's a common judgment. You have to bring in before this court, either make the others, all the other persons parties to the instant proceedings. That's the only way how I can exercise the review jurisdiction. Because without hearing them as to whether these persons are, they have the difficulties if this court has allowed the review. There might be a question out there, I may go for the recall, which may affect them.
That I understand.
So
but-
therefore, you have to make everybody a party in this petition or bring everybody as a review petition. Because you have to either make you may get hold of all the counsels who are there. You were the counsel for a batch of petitions wherein you challenged the commission's report.
Yes, ma'am.
There were a batch where they have only challenged on the parallel proceedings.
Yes, there was a batch.
Now that parallel proceedings, their senior has given up. But tomorrow, because of them, if I recall the entire thing, they have to be made parties in this application. Without making them parties, how can I take up this matter? Because tomorrow, if I recall, they may not like it. Best of one, how do I do it?
No, it's not the behest of one, my lord. There were around 10 appealants before the division bench, my lords. But the issue today is this, my lords.
Then you make those the review petitions and make those other persons parties to the proceedings where they will agree as to yes, we have no objection in reviewing the order. Otherwise, the review is not maintainable in this. Otherwise, apart from the thing, I don't agree what the division bench did.
But I'll otherwise also satisfy, my lords.
Unless
that
I-
Assuming, my lords, order 47 applies to your lordships, my lords, the rigors apply, then the order 47 rule 8, my lords, your lordships, my lords, as a review court, has the, my lords, the discretion to restrict, my lords, the review only to a particular issue or a particular point. That's a settled law. That initially, my lords, there was divergence of views between various high courts. Calcutta High Court said that no, while exercising review jurisdiction, the court can confine the review to a limited part of the judgment instead of touching the entire judgment. The other view, my lords, was that that the entire judgment will have to be recalled, because Order 47 Rule 8 says, my lords, once the review is entertained, a noting will be done in the register. So the argument was that does it amount to the opening the entire judgment? So the courts have said, my lords, that when, my lords, the review is confined, that's ultimately the discretion of the court, the review court. The review court, my lords, while exercising that power, can restrict the scope of review only to a limited part of the judgment, or, my lords, to that part of the judgment which the other person has come before the court, my lords, for review. And that is a permissible. Ultimately, it's the discretion of the court. I will not say, my lords, that your lordships cannot do it, but the decided cases say, my lords, that in a case where
Mr. Chaudhary, unless the Supreme Court says in this manner, otherwise my philosophy of a review is, my first thing is, I will look into the first and without hearing the other side.
Yes, madam.
If I think that a case is made out, then I will issue notice that an error apparent is there, is apparent.
Yes.
And as such, there's a prima facie case to that effect, so look into it. They will file their reply, then I will review it. Once I review it, it is recalled. And then the matter has to be heard afresh. This is unless the Supreme Court says otherwise.
Yes, my lords. I will place, my lords, one decision of the court, my lords. If I may, my lords.
This is by?
This is, my lords, 2005-53 SCC 427. Have you handed over? Just first give the Supreme Court judgment.
Yes.
Yeah, my lords, an appeal was filed after, my lords, there was a part review. Please have para 34, my lords, where the Calcutta High Court view, my lords, is endorsed. Para 34, my lords. In Gaur Krishna Sarkar, Asutosh Mukherjee J, speaking for a division bench, opined that the court is competent to determine whether, when a review is granted, the case should be reopened in part or in its entirety, and that the view cannot be supported on principle that whenever an application for review is granted, the entire case must of necessity be reopened and reconsidered. It was observed that when a review is made, the original decree ceases to exist as a result of the decision of
The
justice.
Supreme Court only referred.
Yes. Well, so
we have three things which Supreme Court does of a High Court judgment. Either it sometimes refers it or relies it. In fact, it would not come within the category of relying also.
No, it relies on. That's the view endorsed by the Supreme Court.
No, it's not. Merely the Supreme Court refers to many judgments. So it's a case of refer, not rely.
It says endorse that view, my lords, of the division.
Endorse is another thing. Endorse is too far off. Here it only says about 34, says that this is it. Then it doesn't say that the Supreme Court never says out here that we endorse the view of the Calcutta High Court.
It's happened, my lords. The court is saying,
yeah,
speaking for a division bench, opined that the court is competent to determine whether, when a review is granted, the case should be reopened in part or in its entirety. And that view cannot be supported on principle that whenever an application for review is granted, the entire case must of necessity be reopened and reconsidered. So the view of Justice Mukherjee, my lords, in Gaur Krishna Sarkar, my lords, is endorsed by the Supreme Court. Now, this view, my lords, even otherwise, was prevailing, my lords. Bombay. Mr. Kohli, I'm referring to 2005 3 SCC 427.
I've got it. Thank you.
Yes, read this judgment because you see, forget about the Supreme Court. This is a division bench judgment of the Calcutta High Court of 1922.
Yes.
And therefore, this judgment is binding on
At
upon
that
me,
time, yes.
taking into account that
We were one.
of the Assam High Court order of 1948.
But this is the judgment of Justice Mukherjee, my lords, which the Supreme Court follows, my
That is
lords.
what I'm reading.
And my lords, one more view by Justice Subbarao, as his lordship then was in Andhra Pradesh, my lords.
No.
Subramania. No, my lords. Justice Subbarao also says, ultimately it is, my lords, the discretion of the court.
Kindly see page 489 of the judgment.
Yes, ma'am. Before that, my lords, 487, last part, if your lordships take, my lords. 487, my lords.
Yes.
We are not now concerned, the last 4 lines, my lords, we are not now concerned with the question whether when the application for review is granted, the decree is vacated in its entirety or only in part. The decisions in Bhubaneswari versus Ajodhya, Sadararuddin versus Ikramuddin, Janki Nath versus Prabhasini, and God Sambar versus Rakhar Raj indicate that the court is competent to determine whether when a review is granted, the case should be reopened in part or in its entirety. And the view cannot be supported on principle that whenever an application for review is granted, the entire case must of necessity be reopened and reconsidered. When, however, on the grant of an application for review, no reservation is made, it may fairly be assumed that the entire case is intended to be reopened. Now, what your lordship was referring, my lords, to
Whatever may be,
Yeah.
the moment, therefore, what you get to understand is once you grant a review, because the review has to be allowed. The review has to be allowed. Then hearing will be confined in the writ petition only to the limited extent.
No, yes, lordship is right. But under Order 47, Rule 8, a noting has to be done.
Whatever may be.
So at that stage, this is what the decision says.
No, that order cannot be passed in the review petition. You see, if you read this judgment also, you cannot pass an order in the review petition. You have to pass the order in the writ petition, but when you review it, you may say in the review itself that the review is only granted to the limited extent.
May I say this much? Because your lordships will first, my lords, take up the review. And once if your lordship is satisfied, then my lords, your lordship under order 47 rule 8 is required to make an endorsement in the register. It is at that stage, when your lordships is granting the review, that your lordships will confine it to only those issues which your lordships. That's the prerogative of the honorable judge.
Then the judgment is open only
To that extent. Yes, I'm grateful, my lord.
And therefore, there has to be a rehearing of the judge of the case.
No, not the entire case.
No, only to that limited extent
very
by
grateful.
which the review has
I'm
been.
very grateful. I'm very
But
grateful.
this is done by some other judge. But what has happened out here in this case is at 489. Can you
Yes,
see what
yes.
the Calcutta High Court said?
Yes, my lords. 3 points now required. My lords have that paragraph.
Yes.
3 points now required to be emphasized. In the first place, when the judge decided to grant the application for review, he should have recorded an order. That was what I was saying.
Yes.
To that effect, and a note thereof should have been made in the register under order 47 rule 8. The order should have stated clearly whether the decree was vacated in its entirety or not. It has second place. The decree in the present case must have been set aside in its entirety, though the judgment states that the review was granted on 2 specified grounds. There were 2 points in controversy, namely, first, whether the rent of the tenure was enhanceable, and secondly, if enhanceable, how should fair and equitable rent be assessed? Though the ground for granting the review as specified in the judgment relates only to the second of these points, it is clear that the first question also was reinvestigated. Such reconsideration would be permissible only if the original decision had been vacated in its entirety. It says that the court, my lords, is empowered to restrict the review. In this case, my lords, my grounds of review is only one, my lords. Paragraph 139 to 912, which I beseech your lordship, my lord. That is today, my lords.
Because that has to have a, this court finds it at a later stage, that look here, this has a bearing on the question of suspension. A question of suspension will also come in because you see, this court have directed them to review the suspension on account of the fact that there shall be no further proceedings. So question of
periodic review, your lordship said. Yes.
So that has to be done, and therefore they may have thought it, because then these direction may not be there. So then that part is also open. After opening of that part, yes, maybe the question of the commission's inquiry may not come in, but the remaining things will come in.
With due respect, madam, but with due respect, let me just, with due respect, the findings and
these two are open. Yes, the commission's inquiry may not come in, but the remaining all other things.
No,
are open.
no, my lord, with due respect, but let me just endeavor, my lord. Let me just endeavor.
Anyways, not today. We issue notice on the what you call the
My lord, may consider allowing it, my lord, because
I can't without giving
my friend is here.
Mr. Kohli, you have objection?
Yes, Lordship, I would be filing definitely objections, Lordship.
No, on the interlocutory application for
No, not a condemnation of delay, Lordship. We will file it. We will, of course, file a response. I'll have to take instructions what the department would like me to say.
Well, let's, one second. Will your lordships come back?
How much time? 4 weeks?
Will your lordships
In
have, my
that
lord,
fair, Lordship.
page 224? Will your lordships have page 224?
No. Mr. Chaudhary, today is only for this.
No, my lord, then
Because again, another thing, this court goes. I don't have the jurisdiction to touch the review unless and until I condone the delay.
yes. Yes.
So I have to condone the delay.
Yes.
So
No,
without
please see
condoning
my
it,
application.
without giving them the
No,
opportunity
please see
of
my
filing.
application today, my lords. Please see my application today.
Look at that
I was
application.
litigating before the division bench. Division bench has given me the liberty to come before your lordships. I have come before your lordships on the very next day, my lords. I filed the petition. Your lordships will have to see, my lords, whether is this an application for condonation which at all, my lords, merits a reply from the other side, especially when, my lords, the other side conceded to that. If your lordships recorded page 224. Mr. Kohli, learned senior counsel appearing for the respondent state, has agreed to such a view taken by this court. Right, my lords? Based
In
on
light
that
of
order,
Nayak, Lordship, in light of state of Maharashtra and Nayak, in terms of para 4 therein, because I pointed out, Lordship, respectfully, that this could not have been an appeal because this was a consent order. In terms of Lordship, it took the doctrine of election. The other batch was completely based on this. So we pointed, how could there be an appeal? The right course would be to come back before the Honorable Single Judge. And in that also, Lordship, there are 2 courses of option. whether a clarification or a review. So if a review is to come, we have no objection to him coming before the learned single judge. But certainly we will file our objections, even if Lordship issues notice on condemnation or dealing.
No, please have page 224, the division bench order, the last 3 paragraphs I'll place. Because the issue is this. Today, I am
Mr.
I'm in a very
Chaudhary,
different position.
Mr. Chaudhary, if you keep on showing the division bench order, you are
No,
not
I
going to get anything.
No, I understand.
I'm telling you,
I understand.
I'm not pleased with that.
I am before my lords, I am before your lordships.
I'll make it very clear.
Well, the only anxiety, my lords, is this, my lords. Your lordships will then consider, my lord. My only anxiety is this. Now, departmental proceedings on the same set of facts, same witnesses who are witnesses in the criminal trial, are, my lords, has been started. They are going on with a speed. That's why, my lords, the division bench has said, my lords, with some alacrity you move, and the single judge should consider it, my lords, on an urgent basis. That's why I'm not saying anything.
Ask the Chief Justice on the administrative side to give a separate bench, not to give any other bench, only for taking up this matter. Ask the Chief Justice on the administrative side. Let him do it. Then we'll take it up.
We have full confidence on your lordships, my lords.
Not that this manner. I'm not going to do it like that. First of all, Mr. Chaudhary, there is a big problem. Others are not here.
Well, I'll do that. I'll do one thing, my lords.
Others are not here. You may have to file and review another application where you have to make all other petitioners a party to the review application, because that is necessary.
May I say this, my lords? I will do that.
One application also will do. One review petition also will do, where others are made the party, because you see, there were various writ petitions. Now everybody has come up with a grievance. One person may not like it. Unless this court finds it that yes, it is an apparent mistake committed by court, means although this is a requirement, error apparent, but it is so gross that forget about them. We are not, in spite of that, this court thinks that the order needs to be recalled.
Because to be candid before your lordships, I see what is falling from your lordships. That also, my lords, has weight, my lords. But what I am saying, to be candid, is this, my lords. Today, my lords, on the same set, they are proceeding against me. If I am entitled, if law permits me,
for them to do it here will be preponderance of probability.
Yes. But my lords, my defense is the same. I have to disclose my defense in my written statement.
You have categorically put your defense earlier also.
No, my lords. No, not
you had no option. The reason why I'm saying is, when I was hearing the matter, I was surprised to take note of that you have filed your reply. The statement of defense was filed, inquiry officer was appointed. Yes, so therefore, that point you have no point.
No, but those allegations arose out of the report, my lord, the recommendations of the report.
But no, on the other facts also you have mentioned. Kindly see your reply.
Understand. Now, my lords,
your reply, you see, I think those clients, after meeting you, thought about the Rule 8B.
In fact, your lordships have been
prior to that, your clients was going very.
Yes.
Yeah. In fact, therefore, the earlier set of writ petitions which were filed by Mr. Ken Chaudhary did not touch on Rule 8B.
Section 8B, yes. Yeah. In fact, my lord, your lordships were kind enough to say, my lord, to give us the liberty that the clients, the petitioners, that if they want to amend, they can amend. But what has happened is the state took a decision, my lords, to de novo conduct a fresh inquiry. So the earlier so-called notice was withdrawn. Now, my lords, the de novo so-called notice.
Have you filed your reply? No. Oh, if you don't file, you take
it. The difficulty is this.
You take your action immediately.
The difficulty is this. That's why, my lords,
you file
if law permits me, my lords, a remedy, my lords, why should your lordships, my lord, withheld that remedy?
Because of the fact that point you should have urged then.
No, that cause of action has got over, my lords. That cause of action of 30th November 2023, so-called notice.
Anyways, today I'm not going to hear. You have enough time from 3 o'clock to 3:40. See, the other councils then have to wait till 6 o'clock.
Prerogative, my lord, your lordship. What can I say? What I'm saying is this, my lord. My only anxiety is the...
No, nothing. Mr. Kohli, we condone the delay and we issue notice on the content and review petition. File your reply. Heard Mr. H. Chaudhary, the senior counsel, assisted by so-and-so, appearing on behalf of the applicant, petitioner, applicant, and Mr. N. Kohli, the learned counsel, appearing on behalf of the respondent numbers 1 to 4. Is an application for condoning the delay of 111 days in preparing the accompanying review application filed seeking review of the judgment and order dated 1/4/2026 in WPC number 6191/2024 and other connected with petitions. Taking into account that the petitioner applicant has approached this court pursuant to taking into account that the petitioner was earlier pursuing an appeal before the learned division bench and thereupon, upon leave being granted, have approached this court filing the review application. It is the opinion of this court that the grounds mentioned in the instant application, more particularly at paragraph number 4 or 5, constitutes a sufficient cause within the meaning of the Limitation Act 1963. Accordingly, this court condones the delay of 111 days in preparing the review application for which the application stands allowed. The registry shall register the accompanying review petition and thereupon list this matter. When?
At the earliest, my lord. I'll leave it to your
The
lordship.
review petition has to be registered also because they don't register without their IA.
That's a ministerial act, my lord. That
Understood, but it has to be registered. Therefore, we don't have even an order sheet here now. The review petition doesn't have an order sheet because it's not registered yet.
The application doesn't have the order.
Huh?
The application for condonation of delay doesn't have the order of the court. I'm just praying, my lord, at the earliest your lordship speak to it, my lord, sir. I'll leave it to your lordship.
So he couldn't register the review petition on when? Tell me.
Your lordship's convenience, my lord, when your lordship's can. At the
That's fine.
earliest, I would request for next Thursday if your lordships can accommodate me. Heard.
Okay. List the review petition.
Lordship may consider 7th or 8th. I might be able to physically be present.
2026. No, Mr. Kohli, I'm just fixing it on 3rd.
Lordship,
To consider as to whether should I issue notice upon the review.
I'm
petition.
grateful. I'm grateful.
Very grateful.
I'm grateful. Deeply obliged, Lordship.
Yes.
I have filed the affidavit, my lord.
What do you say?
My lord, there we haven't seen much, but my lord, I have seen
When did
that
you file the affidavit?
today, my lord. I have the extra copy, but there is no, we have said nothing much, only my lord regarding the criminal case, my lord, FIR and all. But if your lordship sees the my lord license, that was already expired in the month of March.
Which one?
But the license now they what they want to my lord that cancel license, my lord. That was already my lord expired in the month of March, my lord.
No, we have renewed
No,
that. Lord.
no. After cancellation only they have submitted they have paid the amount online.
No, it's okay. Why? Where have you mentioned that the license have?
My lord, in their writ petition only, if your lordship takes up the writ petition page, my lord, they have annexed page 56, my lord, annexure 11.
Where is it?
Lordship will find the underlined following terms.
31st and must be renewed within the month of April each year.
Yes, it is 25-26, my lord. So it's valid up to 31st of March. It was valid, my lord. During the on the time of my lord suspension, it was not, my lord. License was
So there was no question of suspension.
Yeah, actually, my lord, but since it was already, my lord, expired, no renewal was, my lord, done. So,
No, my question is, that is understandable, but my
Mal-
question is out here.
my lord,
Then why did you suspend something
it has got
when it is
value.
not in existence?
It has got no value actually, my lord. It has got no meaning actually, my lord, because they had no license, my lord.
Have you got your renewal?
No,
I have not placed it here, but as per my instruction, it is there, but I will place it. I will take instruction because this is not there on affidavit. So
Anyway, you place it.
man, let him place it because
An affidavit has been filed by the respondent number 3. You can read it. Just to list this matter again on 23rd of September 2000. No, 16th of September 2026.
I'll file my rejoinder as well. I'll file my rejoinder as well.
The petitioner would be at liberty to file the rejoinder and also bring on record as to whether after the renewal granted to the petitioner's license, trade license for the year 2025-26, there has been a fresh trade license issued with effect from 1/4/2026.
Abla.
Wait, please, Your Lordship, my lord. But here is a case, my lord, where for expansion of the road and construction of drains, my lord, they had encroached upon the PWD had encroached upon my land, my lord. At that point in time, I had approached Your Lordship, my lord. Then the constructions went ahead, my lord, and then a joint measurement was carried out. And it was found that around 3 lechas of land my land has gone, my lord.
Yes, what has happened?
I am the owner of a plot of land measuring 4 kathas, 18 lechas, my lord. Now, some portion of that land has gone while constructing the drain, my lord. No land acquisition proceeding, nothing was carried out. Around 3 lechas of land they have taken, my lord, for construction of the public drain. So at this stage, they should determine the compensation and pay, my lord. Nothing more than that. I had approached this honorable court at the time when the construction was going on, my lord. No interim order was passed. So therefore, the construction went ahead.
What construction?
The construction of the drain, my lord. So in that process, my land has been taken a little bit.
What is your joint verification?
Yes, Lordship. I'm
There-
placing.
This is the joint verification, subsequent joint verification. Earlier it was done, my lord. There is an affidavit.
After that affidavit, Lord.
No, this is pursuant to 23/10/2025.
Yes, Lordship, yes.
Ascending.
Hello. Next page. Sir. Last line to sir.
Same as the earlier report.
Cadastral map.
Go to the civil court.
I'm seeking the compensation, my lord, because they are the
So
public
what?
authority.
Go to the civil court.
There is no dispute, my lord, for me to
They either they say that they could not find out the 3 kathas of
The
land.
3 kathas is there, my lord. They have taken the land.
Three
Lordship will kindly come to their affidavit. Page 24 of the affidavit.
Yes.
Same report, my lord. With reference to the subject above, I have the honor to inform you that as per Honorable High Court order that so and so, a joint measurement is caused in presence of officials of PWD and the authorized representative so and so. A plot of land measuring 4 katha, 15 lechas covered by so and so, situated in so and so. In this connection, a sketch map showing the measurement of the said plot of land under position of TD plus is 4 katha so and so. So my original land was 4 katha, 18 lechas. Now after the construction, it is 4 kathas, 15 lechas.
No, one thing you see, I don't understand why they are saying about the dilapidated condition of the cadastral map.
Yes.
The fact remains that the petitioner had 18 letters. 3 letters have gone somewhere. If the revenue authorities or the Mondal cannot find out the 3 letters, then what to do?
Normally they should have find out.
It is not it is nothing to the means it is not rocket science that it cannot be found out. Obviously, the drain was enlarged. When the drain was enlarged, obviously some land must have gone this way or that way. Maybe not 3 letters. See what happens then, he must have now constructed his boundary wall. So the land which has been found inside to inside was 15 letters. So there were some land this way or that way must have gone. So he must have lost around 1.5 or 1 or 2 letters of land. He must have lost it somewhere. Letters of land will be around 288 square feet. Somewhere this has gone. So something it has to be found out. It is no rocket science that why do you require the dilapidated condition? You have to find out what was the road length earlier and what is the road length now. Matter over there. This court had sought for a joint verification report by an order dated 23/10/2025. However, today Mr. H. Sharma, the learned additional senior government advocate, have produced before this court a joint verification report dated 16/10/2025. In other words, there appears to be no joint verification being carried out pursuant to 23/10/2025. Under such circumstances, this court directs the circle officer, Dibrugarh Revenue Circle, Dibrugarh, along with the PWD officials, should carry out the joint verification and place the joint verification report without fail on 5th of October 2026.
Well, the joint verification was directed by order dated 3/9/2025.
No, here also said, no, 23/10 it says, when a matter is called for, SS Troy Beach have submitted, some more time may be required to carry out the joint verification.
Original joint verification was directed by
Understood.
3/9. my lord.
When they say that it is required for to carry out, this court will assume that there is no joint
Yes.
verification. Why
But by
will I
that time
go
it
into
was done.
that?
By that time it was done, it appears so.
Or if you want,
No, my lord. What I'm saying
Anyways,
is that
we have it some other day, not necessary. Because this order would have otherwise aided you, but it is not going to help you. Mr. H. Sharma, the learned counsel appearing on behalf of the additional senior government advocate submits that some joint verification has been carried out. He would like to bring on record by filing an affidavit. This is the matter on 5th of October. Because this is not going to help you out. He will bring on record that.
Lordship, yesterday I have filed the adjournment slip for taking adjournment but I failed to mention in the morning actually.
What is this matter about?
Lordship, this is the petitioner, the property of the petitioner was seized actually.
What?
But no show cause notice was issued to the petitioner. Petitioner and her husband was the joint owner of the joint owner of 2 flats in Kolkata. Lordship, respondent number 3 has filed their additional affidavit on.
Yes, what do you have to say?
Also, I have to seek instruction in regard to the notice.
After 6 years, there is a stay operating on a money laundering proceedings. You are government counsel.
No, on behalf of Ardhar,
Ardhar.
Retainer Council of
My
ED.
goodness, God help. CBI?
No,
Mia?
ED.
ED. God help ED. After 6 years, you are seeking for an instruction. This court duly takes note of that on 29/10/2020, the learned coordinate bench of this court issued notice and state the operation of the notice dated 29/5/2020 issued by the Assistant Directorate, Enforcement Directorate, Assistant Director, Enforcement Directorate, Gauhati Zonal Office. Almost 6 years have gone by. Today, the learned counsel appearing on behalf of the Enforcement Directorate submits that he requires time to obtain instruction as to whether notice was issued. It doesn't appear before this court that the respondents are serious in the present proceedings. Considering the above, this court therefore fixes this matter again on 16th of November 2026. In view of the lack of seriousness on the part of the Enforcement Directorate in the present proceedings, this court extends the interim order passed on 29/10/2020 until further orders.
My lord, application
What about certificate?
my lord, that is
Elephant
pending,
certificate?
that is pending for consideration. My lord, the difficulty arises when she gives birth, my lord, one calf. And the office, my lord, insisting that the elephant be bring to the office for inspection. And on the part of the petitioner, it is difficult for the time being, my lord. So, my lord, some time is required on the part of the petitioner also to the elephant to the DFO office, my lord, for inspection.
Your petition, you don't, as of now, you don't have a ownership.
Yes, my lord, because it expires.
So you cannot claim this relief.
My lord,
You file a separate application whenever it is. We close this petition unnecessary.
my lord, this court.
Whenever you get the permission, ownership, then apply. If they don't consider, you come here.
But
That is the only way.
this court directs earlier that granting liberty to the petitioner.
Yes, that was 3 years ago. 3 years ago.
Lordship, but they are delaying.
For that, it is a different cost. Lekho.
They are delaying the.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. So-and-so appears on behalf of the Forest Department. The present petition has been filed by the petitioner seeking a direction upon the respondents to issue the transit permission in favor of the petitioner under Section 48A of the Wildlife Protection Act 1972 for transfer of the female elephant. What is the name?
Kansi.
Huh?
Kansi.
Kansi from Assam to Haryana. To stop. It is noticed that 3 years back, the petitioner ownership certificate had expired.
And immediately he filed the application.
And thereupon the petitioner applied for renewal of the ownership certificate. till the petitioner receives a renewed ownership certificate, which the petitioner admittedly do not have today, the relief sought for by the petitioner in the present proceedings cannot be granted. Considering the above, the court therefore closes the instant writ petition with a liberty to the petitioner to assail the actions on the part of the respondents in delaying the issuance of the renewal of the certificate and further consequential release.
Earlier court directs them after filing application, they should consider within 3 weeks. That's not done. I'll.
Obliged.
Sorry. Obliged.
May I please, your lordship? The matter is relating for allotment of room. Galabil.
What is the matter about?
Galabil Market, Golaghat, in Golaghat district, lordship. Allotment of room.
By which the Galabil Gaon Panchayat had allotted 12 room numbers of and no selection procedure was there. Yeah, affidavit filed.
My lord, listed after a long time, my lord, I have received the instruction on June 2026. Lordship may grant some time, my lord, I'll file the affidavit.
Mr. S. Dotto, the learned counsel. The matter came up on 5/8 also.
Lordship,
Then-
not reached, I think.
Why you are saying that it has come last time? You only appeared on the last occasion.
I received.
Then why do you say the matter has come up after last time, long time?
Lord, I found this instruction.
The
very
matter
necessary.
again came up on 22/6. The matter again come up on 2/6. The matter again last time came up on 11/5. Why you are saying?
Actually, my lord, the instruction was on my mail, my lord. I was not, that was not.
Then why you are saying that
Sorry,
the
but
matter
sorry.
has come up after a long time?
Sorry, my lord.
Mr. S. Dotto, the learned standing counsel of the PNRD, submits that he has received the affidavit, instructions, and the affidavit would be filed within by 7th of September 2026.
I can
It is observed that if the affidavit is not filed, the present writ petition on the date so specified above,
Yes.
the writ petition shall be taken up for disposal purely on the basis of the materials which are there on records. This is the matter on 11th of September 2026.
My lord, high lord.
King Kong College. What is this?
Non-payment of contractors bill, Lordship.
This is for non-payment of something or what? A non-payment of dues, na? The UGC or something.
Lordship, UGC.
What is the matter about?
Lordship, we will file a affidavit, Lordship. Lordship, we have written to the UGC, Lordship.
When was it supposed to be completed?
Lordship, March 2020, Lordship.
Then,
We have.
when was it completed?
Lordship, June that year, Lordship, because of the, at that period of time, because of the announcement of national lockdown, Lordship. That is reflected in the affidavit.
Yes, who is appearing for the UGC?
The UGC, no. On earlier occasion, A. Somua.
You are appearing, Mr. Goswami? Who is to pay? You have nothing to do. In view of that, if it was done during the COVID, what is the date of completion? It was supposed to be completed by 31/3.
Lordship,
And it was completed when?
Lordship, June, instead of March, Lordship, we have completed in June.
June 2020,
Lordship,
in the midst of COVID.
Lordship.
So there was a delay. Obviously, and UGC is saying that they are not paying.
Not paying. We have already written to them. We have already written to the UGC
Then?
regarding the pending bills of 40 lakhs.
40 lakhs.
Yes, Lordship.
But was the amount sanctioned by the UGC? Obviously,
Lordship,
the UGC
this
must have
one-
given you a grant.
Lordship, this work was in continuation of a scheme, Lordship.
It was a girls' hostel.
Yes, Lordship.
Then?
There's only 1 month delay due to COVID-19 pandemic.
No. I think we can
We have written to
direct them. Well, today we do it on another day. Let's have it on 31st again. I don't have much matters. This is the matter on 31/8/2026. Hostel. Again, for final disposal. Today, the matter could not be taken up on account of as there was no representation on behalf of the University Grants Commission. You are there. Then why you are not? Why you are keeping quiet? We are asking for the UGC Council.
little late, Lordship.
Huh?
Little late, Lordship.
We are having it on account of non-appearance of the UGC Council. You are there. It would like to beside him. List the matter on so and so for final disposal. We'll allow this thing, direct you to consider and make the payment, taking into account that this happened during the COVID time. This is the order which she will get on the next date.
May please, my lord has granted final opportunity to the respondents to file their affidavit on the last occasion.
May it please, your lord.
No affidavit has been filed.
My lord, an affidavit was prepared, my lord. I could not file it. I don't want to file this, my lord. We are making some modification here, my lord. I can file it by Tuesday, my lord.
Otherwise, the matter would not require much deliberation.
Yes, my lord.
It can be disposed of, my lord.
Yes,
my lord. Coach and Rajbangshi status, they are challenging the notification.
There's an expert statutory committee, my lords, the Assam Backward Classes Commission, my lords, which is vested with the duty to resolve such disputes, my lords. We have, my lords, we made a representation to the Backward Classes Commission, but that has not been disposed of. Now, if there's a direction, my lords, that they should dispose.
So you want it separate, Kutse and Rajbangshi?
Yes.
My lord, we have received the records also. But I am just incorporating 1 or 2 paragraphs. Maybe by Tuesday, my lord, we will file it.
Ms. P. Chakraborty, the Learned Standing Counsel for the Department of Social Justice and Empowerment, Government of Assam submits that the affidavit is ready, but for filing. However, at the time of filing, it was noticed that there were some inherent, certain inadvertent errors for which some correction is required and would be filed by Tuesday without fail. Taking into account such undertaking given by Ms. P. Chakraborty, the Learned Standing Counsel, this court fixes this matter again on 14th of September 2026. In the meantime, upon filing of the affidavit by 2nd of September 2026, petitioner is granted liberty to file reply.
Deeply obliged.
None appears on behalf of the parties. Yes.
Earlier occasion, my lord, respondent number 4 paid for 2 weeks time to file affidavit, but we let on 22/5/2020.
Who appears for Tezpur Municipal Board?
My lord. S. Borthagu. S. Borthagu, my lord.
Yes. They filed.
My lord, he's on legs, my lord, in court 4. He has asked me to, my lord, seek time for filing affidavit.
Respondent number 2 is who? Kulov, sir. No, who you have come against the rejection of NOC by that Tezpur Municipal Board.
My lord.
Chairman
appearing?
S. Porthakur will appear, my lord. He's on legs, so he has asked me to.
Okay, you have it. But why no affidavit has been filed by them?
Yes.
We should have. We have it on again another day. List the matter on 16th of September 2026.
Other than 16, my lord.
18th of 18 not possible. 23rd of September 2026. In the meantime, a final opportunity is granted to the Tezpur Municipal Board to bring on record their stand by filing the affidavit. Failing to do so, this court shall proceed on the basis of the materials on report. Yes, what is this?
Let's see, I pray some time to file a rejoinder to the affidavit filed by the respondent numbers 2 to 4. They have filed their affidavit in opposition. I want to reply.
What is the matter about?
My lord, it's regarding encashment of a bank guarantee.
Huh?
Encashment of a bank guarantee, my lord. However, that the purpose for which we had given that bank guarantee.
There is no stay.
My lord, there's no stay, my lord.
Okay.
Previous.
The council appearing.
We have honored the bank guarantee. We have honored the bank guarantee.
Yes. Well, that we have stated bank
guarantee
guarantee.
has been invoked, my lord.
Encash.
Bank guarantee has been invoked.
Yes, my lord.
But he has the prayer for reimbursement, no?
Yes, ma'am.
Let us look into it.
Even, my lord, otherwise, even if it is having allegation of fraud, invocation of bank guarantee is an arbitrable dispute. My lord.
You have filed affidavit?
Yes, my lord. And arbitration clause is there, my lord.
Okay. Mr. A. Batra, appearing on behalf of the petitioner, submits that the affidavit in opposition has been filed by the respondent number 224 only on 25/8/2026. An opportunity may be granted to the petitioner to file an affidavit in reply. Taking into account the above, list this matter on 16th of September 2026. In the meantime, the affidavit in reply be filed.
May I please, Your Worship? Worship, in this matter, I have filed affidavit in reply, but it's not in record and it's not showing in the site also, my lord. So, Lordship, may grant some time, my lord, I'll check what is going on.
What is the matter about?
Matter is, my lord, non-renewal of my allotment, my lord.
Huh?
Non-renewal of my allotment and the SIDC, my lord, said, my lord.
And what is the interim order passed?
My lord, interim is there, my lord.
What is the interim order passed?
No coercive action, my lord.
Huh?
No coercive action, my lord. For no
Full
coercive
possession of the petitioner over. You are in
position, my lord.
possession.
Yes, my lord.
And why is it not renewed?
But we have already intimated them, my lord, we are not in a position to renew the lease, my lord. 10 years already expired in the year 2025. We categorically mentioned that we are not in a position to renew because we have sent a proposal to the central government for construction of a flatted factory, my lord, which will house multiple of such units, my lord. So now, my lord, they are, my lord, trying to compel us to renew the lease, my lord. That's the only thing.
My lord, only two ground, my lord. First ground, my lord, no, that already, my lord, proposal has been sent, but not yet sanctioned. Second, my lord, there are vacant places, my lord. We can relocate it, my lord. We are 5 families are only because of this, my lord.
So what is your right?
My lord, it's a government, my lord.
Government, if it is
notification, my
government, you can seek for renewal.
But,
Is renewal an automatic right?
They have accommodated others like same, my lord, as
Is
per
it?
my pleadings, my lord.
No, my lord,
We
we
have
have
pleaded.
categorically mentioned, my lord, in our affidavit also, my lord.
It has been submitted that the affidavit in reply. But there is no interim order extended from 25/8/2026.
My lord, some maybe not recorded, my lord. I prayed on the last day.
File application then. Mr. So-and-so appearing, Mr. S. Dutta appearing on behalf of the petitioner submits that an affidavit in reply was been filed in the present proceedings. However, the same is not on record. Is this matter again on
Short date, maybe, my
14th of September 2026. In the meantime, the petitioner in the registry shall bring on record such application.
Alia, please.
May it please your lordship. Lordship, in this matters, my lord, we have sent our affidavit for vetting, my lord. Kindly be taken out after weeks my lord, for filing of the affidavit. my lord.
What is this for?
Well, there is a land acquisition matter, my lord. The procedure has lapsed at the middle stage. my lord.
Ms. So-and-so appearing on behalf of the Standing Council BTC submits that the affidavit in opposition has been sent for vetting and would be filed in 2 weeks' time. To establish this matter on 23rd of September 2026. In the meantime, the BTC shall bring on record their stand by filing the affidavits. Interim orders passed in both the petitions stands extended till the next date.
Obliged.
What is this?
Lordship. May it please your lordship, we are awaiting some more instruction, lordship.
Huh?
So we need some time to file our affidavit.
When are you filing it?
Lordship, September 1st week.
Ms. So-and-so appearing on behalf of the State Bank of India submits that the affidavit in opposition would be filed by 2nd week of September. To establish this matter again on 23rd of September 2026. In the meantime, the affidavit be filed by 18th of September.
Mass obliged.
May I please? In this matters, your lordship, petitioner was the chairman of the cooperative society, your lordship. Actually, the matter involves, your lordship, the time for holding the AGM was elapsed, and that thereafter, your lordship, petitioner being the chairman, was the chairman of the cooperative society, submitted an application for extension of time for holding the AGM, your lordship. That was rejected by the assistant registrar of cooperative society. Thereafter, he submitted an application before the register that was also rejected, your lordship. Being a brief, he has approached.
Who is the petitioner?
Petitioner was the chairman, your lordship.
Now,
lordship, as per the act, your lordship, it is the secretary who has to take initiative for holding the AGM, your lordship. But in the previous,
what is this? Why you are not permitting the petitioner to hold the AGM? Otherwise, he will have the problem with section.
Section, your lordship,
by which it will become used as there's the section now. What is that?
No, my lord, already he failed. By 30th of September, he was supposed to hold it. My lord, that he failed. So therefore, my lord, the board
automatic
board dissolved, my lord, 39. Board under section 39, my lord, board stands automatically dissolved.
Then what happened?
Then, my lord, one-man committee has to hold the election AGM.
When? That is in September. It's September 2025. We are in August 2026.
Yes.
What is your jurisdiction to continue?
Yes, my lord.
As per 41(6), you can't continue beyond that.
Yes, my lord, within 45 days, my lord, election will be held. Lordship will close the matter, my
before the may I submit, your lordship, it is the for which the AGM could not be held, your lordship, that has to be look after, your lordship, because there
I
was
understand, otherwise we'll have a problem 41. Section 40 provides various disqualifications.
But secretary, as per the section, your
I
lordship,
understand
49, 49E, your lordship, secretary has to take all the initiative. But because of the earlier orders issued by the assistant general register and also by the register, your lordship, there were anomalies which has been clearly established before the against the secretary, your lordship. That's why he has not hold the AGM in apprehending that all his corruption will be come out, your lordship. And also, your lordship, balance sheet has also not been submitted in time.
You want an AGM to be held.
Yes, your lordship.
You have a problem because you will be otherwise disqualified.
Yes.
Because of not holding, you become disqualified. That's the, isn't it the?
Yes.
So you are the president? or the
Chairman,
So
elected.
you will become disqualified in view of section 44A. Wouldn't you come within the ambit of 44A? If I today ask them to hold the election, wouldn't you come under the midship of 44A? You cannot participate. You want to participate or not?
Yes, Your Lordship.
Finish. So therefore, one has to adjudicate. That day I passed some order. When it came as regards, only look into 41.4.
Where the board fails to arrange the holding the election of the directors or delegate, the case may be before the expiry of the term. Or the directors, investigate director.
So if we hold that, the board did not fail. But it is the secretary who failed.
Your Lordship.
For that, you cannot be held responsible.
Responsible.
Then the thing would be better. Who is the secretary? Yes, what do you say?
I have submitted my affidavit in opposition.
You failed to do it.
No, my lord. I tried, my lord, because, my lord, there is some allegation, my lord. But all allegation, my lord, they submitted FIR, which, my lord, annual report submitted, my lord.
But
There is
this does not stop you from holding the elections.
Yes.
Why you're not doing it? In the,
Well,
does your
already-
officials like to do all these things?
Well, already notice has been issued for correction of the voter list, my lord. I have annexed that document.
No, my question is, does your officials like it to be in the helm of the societies? I think so, no?
It appears so.
Ah.
The lordship will direct within 45 days, my lord, it will be held. I'll, my lord, convey my the order. It
Yes,
cannot
my
go on and on.
No, this cannot happen.
Yes, yes, correct. But my lord, 41.4 says, where a board fails to arrange for holding. My lord, the duty is cast on the board.
When the board fails, then only it discharges. 41 says about elections.
Yes.
39 says about AGM.
Yes.
Isn't it?
My lord, but your lordship will
And
say.
there is a particular section that in AGM there will be the elections every 5 years.
Yes, ma'am.
Anyways, we do one thing, we finish up this matter. Because I can't grant you the leave, because if I granted leave to you, he will be finished. He cannot contest.
Hmm.
Any contest.
Yes, he cannot. There is a bar, my lord.
He cannot contest.
Hmm.
But he doesn't have an interim order also.
Yes, no interim order.
So therefore, there is no bar for you to hold it.
Yes, yes.
You are in the helm of affairs, isn't it? And more particularly in view of that division bench judgment.
Yes, Your Lord.
Because now the secretary's position has been made to that of the CEO, isn't it?
My lord, yes.
I have serious reservations on that. Because then the board's power has been finished. He can continue. The board cannot. Anyways, can't help it. It's a division bench judgment. We fix it on this will matter again on 10th of 10 not on 17th of September 2026, on which date an attempt shall be made to dispose of the reproach.
Oblige.
Yes, sir.
May I please, Your Lordship? Lordship, we are required to file the affidavit and reply, Lordship, but the.
You have filed affidavit?
Yes, madam, we have
File reply.
We want to file a reply, Lordship.
Counsel appearing on behalf of the petitioner seeks for some time to file the reply. Leaves the matter on 6th of November 2026.
Much obliged, Lordship.
May I?
What is the matter, Mr. Mondal?
My lord, the Village Road, my lord, has been blocked by the, my lord, APDCL and the, my lord, other respondent authorities,
Okay, affidavit's not filed.
not filed. my lord.
No, no, I am for the Lordship, Deputy Commissioner Lordship. Today I have received the extra copy Lordship. So I may given some time Lordship. Because
Mr. N. Goswami, the learned counsel appearing on behalf of the petitioner, respondent,
some respondent Lordship.
on behalf of the district commissioner submits that he has received the extra copy today to establish this matter on 4th of November 2026. In the meantime, the respondents shall bring on record their stance by filing the affidavits.
And in the meantime, my lord, some interim protection may be granted. my lord.
What is the interim protection?
The, my lord, the ingression and aggression are restricted by the respondent authorities to the village.
No, no, that is by the APDCL Lordship. I cannot tell.
Yes.
There is no interim order passed all along.
Lordship.
How can I give you? Let them file. You have given him the copy today.
Lordship, Lordship, that's
Yeah.
not, that's not, copy. Obliged Lordship.
Obliged.
Mr. Sharma, what is it?
Lordship, I filed for, prayed for remission, Your Lordship, and the represent. In the meantime, they have disposed of my representation, Your Lordship, on.
Considering the above, the learned counsel for the party shall place necessary instruction whether the petitioner submitted the representation dated 25/7/2000 and whether any receipt was obtained from the officials of the
No,
agency.
no, there is not. We have not received any.
That is your stand.
Yes, our stand.
I have therefore asked you to get your information as to do you have a receipt?
No, Your Lordship. I have
Therefore, they
taken
are
instru-
saying that the representation
Yes.
has not been submitted.
I have obtained instruction, Your Lordship, that they have submitted in the office, but no acknowledgement. Maybe dealing with it, no?
No acknowledgement.
Then it has no value, no?
That's why we may be granted liberty to again consider my representation that we can submit it, Your Lordship.
For
Everything has ended, Your Lordship, and even
As
the,
regards your remission has been rejected.
and moreover, Your Lordship, the demand, amount in the demand, that is wrong calculation. It should be not 59 lakhs, it should be around 30 lakhs something, 30 lakhs something. I have calculated and
We do one thing, we finish this on Monday. I will pass an order to the effect that you will submit a representation giving all these things
yes,
as regards this, because the representation is not there, so you submit here. Whatever maybe you submitted, they will consider within the contours of the law and reputation stands here. But this is, what is your prayer for that?
yeah, my
This is
prayer
for
was.
the,
one
only to
for-
the extent I can permit is as regards wrong calculation, nothing more than that.
That we'll calculate it, Lordship.
Hmm?
If it is wrong, we will modify it, Lordship.
Termination, gone.
Gone.
Remission, what is there has been rejected.
Yes.
And then your representation which is there,
Is-
surrender, accept to his surrender. Oh, you have surrendered.
No, we are in represent dated 25/7. We have prayed either to grant remission or to accept our surrender. Now subsequently, we again file a represent on 3/6/26. That has been rejected now. So I am
remission- no,
praying,
Remission has been rejected.
remission has been rejected.
So therefore you have, your surrender has to be taken note of.
Yes, yes, yes. Your
Let them submit a payer for surrender. You will consider that.
Yes, yes, Lordship can dispose it also.
Monday, not today. List this matter on Monday for final disposal.
This much and recalculation, Your Lordship.
And also the calculation. Oh, calculation for what?
Demand notice there.
Demand notice, okay. To that effect. Calculation is only permitted, nothing more than that. Yes, what is this? What happened?
May it please your lordship. Lordship, this is regarding the pendency of Bakijai proceedings.
Is it going on?
Lordship, I just, while sitting in this courtroom, I got a notification, letter from the Bakijai department saying that dated 24/8/2026. Does the lordship have the same same letter? Addressed to officer in charge, Dispur police station.
So there is something done.
No, lordship, they have already entered appearance. They are saying that they have not entered appearance.
Okay. Mr. Goswami.
The respondent had filed this on 30/6/2026. So they have entered appearance. How are they issuing a letter saying after 3 reminder they have not appeared?
Okay. It's fixed on 11/9.
11/9.
11/9.
You'll appear there.
And there is one more proceeding, lordship, in which they said that RERA was asked for some clarification.
Rera, who is appearing?
For that also, the government was asked to produce the updated status. There were two proceedings. This is regarding one of the proceedings. The updated status about the other proceeding is not
Has
brought on
been taken,
record.
my lord, if your lordship comes.
Who is appearing for Rera?
Right, was for the night. Instruction.
On the last occasion also, lordship, nobody appeared for RERA.
We'll take a first step on them.
Isn't Rera a government body? Government of Assam? No.
No, my lord.
It is.
Mr. Das,
Even, my lord.
Rera is government?
Rera, my lord.
No, it's an independent authority.
It's an independent authority.
This court duly takes note of that the next stage has been fixed in Bakijai PS. Bakijai. Bakijai, which case?
Bakijai case number 9 of 2025.
9 of 2025 is fixed on 11/9/2026 at 12:30 PM. Mr. B.D. Goswami, the learned counsel, appearing on behalf of the respondent number 6 in the present proceeding, submits that the respondent number 6 would appear before the Bakijai officer on the date fixed. So an update be provided by the respondent number 6, update be provided. On 7th of October 2026 in the respect to the said proceedings.
Lordship, with respect to the other proceedings, nothing has been noted.
We'll see when the first get one.
Yes.
Why one with petition for two proceedings?
Because same party, same RERA proceedings, one was for refund, the other was for compensation. Same parties involved. Obliged.
Lordship will approach the, as per the SOP, your lordship, this may be disposal, we'll approach the bank as per the SOP.
Cybercrime.
Lordship.
Wait, please, your lordship, I'm appearing for the respondent number 2.
How much amount?
It's 40,000, your lordship. The total amount is 40,000 in my account and disputed amount is around 4,690.
No. Lordship, not 4,600. It is 4,990. 4,919.
You filed affidavit?
Yes, we have filed the affidavit today.
Where?
Today, lordship.
You have a copy?
We have received it.
Where have you mentioned?
Lordship, at Annexure 1, page number.
This is paragraph 3.
Yes.
Was that the transactions were not in the line with the declared so and it automatically gets freeze if the system detects suspension. It is further submitted an amount of air has been marked as lien of the fraud. So is it frozen now?
Yes, it's Lordship, it's frozen since.
Yes.
You lift the frozen, keeping this on lien.
Okay.
Keep a lien of 4,990.
Lordship, there are some more instruction regarding this account, Lordship. Some mullet transaction has been done in this.
What?
Mullet transaction has been done in this present.
What transaction?
Some more transaction has been done in this present account, Lordship.
What
So,
transaction?
Lordship, as per their affidavit, they have stated that the disclosed income that we have disclosed in our KYC, it's not in line with the transaction that has been carried out in the account. So, for example, if we have disclosed 3 lakhs rupees, the transaction that are carried out is more than 3 lakhs rupees. That is their main contention. That's why they have said that it is a mule account. So, that is their main contention.
You are paying for?
bank close.
Who are you to say? ED will see. Isn't it?
No, we have yes, Lordship.
If the ED says they will ask you to do so.
Yes, Lordship. Okay.
You may report it, they may ask you, then you do it.
Okay, Lordship. God bless you.
As of now, the disputed amount is 4,990.
90,
So
yes.
keep a lien.
Yes.
Then you cannot say all these
Yes,
things.
Lordship.
So if the bank is now become to decide it is a mule account, it will have a, what will happen? Disposed.
Lordship.
God bless you. My lord, in this matter, I have served one copy today, affidavit in opposition, my lord. We are going to file by tomorrow, my lord. Already served copy.
Appearing on behalf of the
PNRD department.
the department submits that the affidavit will be filed by tomorrow, Monday.
My lord. I have already served copy. my
Yes,
lord.
yes.
Copy of the same have already been furnished to the Senate Council appearing on behalf of the petition. Taking into account the above, list this matter on urgency, no urgency.
I don't know.
Okay, list the matter on 7th of October 2026. In the meantime, the petitioner would be at liberty to file reply.
I'll let this.
Because September is filled up now.
My lord.
Yes, what is this?
My lord, this matter pertains to those matters that your lordship had heard regarding ERV, my lord, equipment return vouchers, IOCL, my lord. Those matters. Now, in this matter, my lord, this matter was taken up for the first time on the last occasion, 29/7. What the Honorable Court observed was that the initial show cause, only one show cause, my lord, it was issued in the month of February last year.
No.
To-
Are you filing an affidavit of what?
No, my lord. Now what has happened, my lord, in one of the matters that had come up before this Honorable Court, your lordship had given us the liberty to dispose of.
To pass the order.
Yes, my lord. Now what has happened, pursuant to this Honorable Court's last order in this writ petition, they were directed to file their response to the show cause before 21st. And we are to hold a hearing before 25th. Now, my senior friend for the petitioner submits that they have
Junior.
no, but, the actual senior, my lord, he's the assistant.
Your Lordship, conducting counsel is out of station, Lordship.
Okay.
My senior friend had confirmed that they have submitted the reply to the show cause. As per my instructions, there has not been any furnishing of any show cause, the reply to the show cause. But be that as it may, the other matters are tagged and listed on 7th of September. Your lordship will give us the discretion to carry out the hearing with or without in the absence of the reply that they have admittedly furnished, and we'll issue eventually a speaking order, my lord. The sum here is 16 lakhs.
I cannot say anything, but you have to you'll give him a personal hearing.
We will give him a personal hearing. As of now, as per my instructions, my lord, the aspect is that they have not submitted their reply to the show cause. My senior friend submits that he has done that. So whatever the situation may be, my lord, even in the absence of
Don't make it complicated. We'll have it on 6th, 7th.
7th. But
List this matter on 7th along with
2928, of 2026, my lord, Messrs Technico, my lord. Similar orders, my lord, and 2928.
Now, what is this 3033?
3033 is another matter, similar matter, my lord. Similar orders have been passed. This
3033 oblique 2026
my lord.
on 7th.
On 7th, that is listed on 7th, but there is a possibility, my lord, that the matters might come up across two different courts, my lord. So if you are
Very good.
permitted to make a mention, my lord, so that on the day.
Mention it before me not to take up.
And my lord, we have the liberty to carry out, my lord, and pass a speaking order, my lord.
Mr. M. Sharma, the learned counsel appearing on behalf of the petitioner submits, appearing on behalf of the respondent submits that a clarification is required as to whether the petitioner, the respondents would be at liberty to pass the speaking order in the meantime. Stop. This court have duly taken note of the interim order passed on so and so date to Salem. And there appears to be no bar upon the respondents to pass the speaking order. The only bar is not to make any deduction.
My lord, grateful, my lord.
Obliged.
Okay.
7th
7th of September, my lord.
37 and 41 similar matter, my lord. So, my lord, I applied for a settlement of the land, my lord. During pendency of the petition, they want to evict us. That is the case, my lord.
I need some accommodation, my lord, some more accommodation to file.
Counsel appearing on behalf of the respondents seeks for an
And in 41
accommodation.
affidavit has been sent for waiting.
Matter
It will be fine.
in how much time?
In 41 Monday, my lord, I can file in 37 2 weeks, my lord.
Same week.
Lodge.
This is item?
It is
37.
37.
And 41.
Yes,
Both
ma'am.
the matters. They are similar.
Similar, my lord.
Both these petitions
Copy I
are,
have, but-
are raises similar issues. It is noticed that no affidavit has been filed by the respondents. Ms. Embormon, the learned counsel, appearing on behalf of the district administration, seeks for some time.
Lodge.
Interim order, you are having an interim order
My lord.
No,
accordingly. This matter again on 5th of October 2026.
lodge.
The affidavits be filed on or before 1st of October 2026.
Obliged.
Yes, what is this?
Lordship, as per last order, we filed an IA implementing the person who have received the eviction notice. Actually, the petitioner is the original pattada in the tribal belt and block, and upon his lands, some eviction notice were issued. So on the last occasion, the honorable court directed us to file an IA implement the
Oh,
person.
this matter, I have fixed it on
Yes.
January.
No, it was, your lordship has fixed it on January, but thereafter in the order, lordship, I have seen it's 6/11/23.
6/11.
6/11 along with, huh?
These are all.
This you
Sure.
want to make the owner.
Yes, I am the owner.
Party,
Petitioner
good.
is the owner.
Owner is misconceived, rejected. Hey, কালি এখন reject কৰিছো। আৰু এইখনত
Lordship, may
no, এহেঁতি একো affidavit file কৰা নাই। এটা order দিছো এটা কালি এটা and fix it on 6/11.
on
Interim
WPC,
orders to extend them, so on.
40 is the same. 40,
it is fixed on 6/11, lordship. WPC, may I give the number?
Our order to-
P952/26.
I think 42.
There also there is an IA which I rejected.
Yes, lordship. I appeared on item 40 is also same.
Item 40.
You were all, you were there in that matter.
Yes, your lord.
You were
No,
the,
no, I
there's
was-
another council.
Another council.
Very well.
Item 40 is also similar to this 38, lordship.
Okay, 40 also same going. Interim order till. Yes, what is this forest?
May it please your lordship. Lordship, I seek some accommodation in this matter to obtain instructions, my lord. Our instructions are awaited.
Okay, counsel appearing on behalf of the BTC
Lordship.
seeks for some time for obtaining instructions to file the affidavit in opposition. What is the matter?
Matter here, Milord, petitioner before lordship is the Moholdar Milord. Since August 2025, he is unable to carry out his Mohol works. Despite the unauthorized obstruction, I made two representatives before the authority to interfere into the matter. I'm been allowed to continue the Mohol, but no action has been
Is this
initiated by the
matter on-
authority.
List this, yeah. Oh, you, Ms. So-and-so appearing, the learned standing counsel of the BTC admits that the instructions have not been provided. Full stop. Taking into account the limited issue in the instant proceedings. And there has been a specific direction passed on 29/7/2026 that the instructions be placed on record. This court fixes this matter on 16th of September
Milord.
2026.
Milord.
There is BTC, the learned standing counsel for the BTC shall produce the instruction failing which this court may seek the appropriate the personal appearance of the officer concerned.
Mass obliged.
Obliged.
What is this?
May I please your lordship. Lordship, in this matter, we have filed our affidavit today.
It is a tender matter, my lords, in which a tender.
Your tender has been cancelled
Yes, your lordship.
and a fresh tender issued.
Yes, your lordship.
And fresh tender is subject to the outcome.
Yes, your lordship.
Then what happened? What remains in your case?
They have filed affidavit in reply. They have filed affidavit in opposition
They
letter
filed.
Yes, lordship.
today itself.
Counsel appearing on behalf of the respondent number
1 to 3, lordship.
One,
Health
two?
Health Department, 1 to 3, lordship.
1, 2, and 3. Submits that affidavit in opposition has been filed. The learned counsel appears
Yes, ma'am.
on behalf of the petitioner submits that he will file a reply
2 weeks time.
accordingly. This matter on 7th of October 2026. In the meantime, the reply we filed.
Sometime in August, man. It's August.
What? Today is
Oh,
August.
sorry, man. It's,
September,
App-
no dates fixed.
available.
September, not possible. Not possible.
May I please tell lordship, I am praying 1 week time for filing affidavit in reply, lordship.
Or
Affidavit in,
respondent?
affidavit in reply, lordship. They filed their
Learned
affidavit.
counsel appearing on behalf of the petitioner seeks for 1 week's time for filing the affidavit in reply. So taking into account the above, matters stand adjourned. We listed again on 14th of October 2026. In the meantime, the reply be filed.
Authorized, lordship.
Rajic Ali.
Last occasion instruction was sought for regarding status of my representation, lordship.
Has been rejected, my lord.
Huh?
It has been
What
rejected.
rejected? Then we put the name in the record. Bring the rejection order. Mr. Endas appearing learned government advocate submits that the application filed by the petitioner in the Seva Setu portal to strike out the names of the other pattadas from the land bearing dag number 45 of KP Patta number 26 of village Soyani, Siani Moniari under Siani Moza was rejected. So it is the opinion of this court that the said rejection order be placed on record. The instruction so placed is kept on record. state in the rejection order be placed before this court. Full stop. The instruction so submitted is kept on record and marked with the letter X.
What the rejection order, my lord? It says in only one line, my lord. The second party has objected during the hearing his or her name should not be striked off. And in the comment section, it says it is written as rejected.
We are not aware when hearing took place, so no information was provided to
Second
us.
part,
as to-
You produced it.
Yes, madam.
Is
Of
this
language.
matter again on 23rd September.
Of my lordship.
If it has to be filed on my lord, the instruction will do.
What is this?
In earlier case.
IA for? Okay. Mr. Sen is not there. Okay, taking into account that the counsel for the petitioner is not there, list this matter again on
In fact, my lord, this case is covered by your lordship judgment regarding my lord.
28th of September 2026. I know that. There is no stay.
No. Public.
Last name.
Before my learned friend submits,
Hmm.
may I pray for segregation of 63 and 64 because we have nothing to do with the revenue department. We have allegation against the APDSL because of disconnection of our electric line. His case is that he has arrayed respondent revenue as a party respondent, and we have not arrayed revenue as a party respondent.
Understood. Mr. Dhar, this court had fixed it specifically for a specific reason. The reason is, if I allow you the electricity today, on the other hand, they are trying to evict you, and you have obtained some order from somewhere. There's some order out there, and therefore you are not being evicted. Then wouldn't both these cases have there will be problem in passing orders?
No.
Because you see, your right to remain is one thing for which you have filed with petitions.
Yes.
Now, because you are remaining, which is also very temporary, taking into account that the question of the court have only directed you to be looked into for your settlement somewhere else. Now, should you be granted the electricity in the meantime? That is another question. So it is interdependent on the question of whether you should remain or not. Once you are to be remain or till certain thing is there, it will be done. We will do one thing. We have it on Monday.
Yes. Since your lordship has already passed the judgment for directing them to pass speaking order. In our case, speaking order has not been passed till date. Therefore, we have not been
So
evicted.
therefore, whatever may be, whether speaking order has been passed or not, we'll consider. If we direct them to pass a fresh speaking order, giving you hearing, then you are entitled to an electricity connection.
Yes, lordship. That is why I am on.
Understood. So therefore, I understand that. But if I'm saying that no, this is enough, then why should I pass the ask them to place the electricity? You get the point? So let me first look into that aspect. Therefore, I'm fixing it on Monday. Monday, actually, what has happened, if you see the calendar,
Yes.
I did not see 31st. And therefore, there is not a single case listed. I fixed a date out here, I didn't see from there 31st. Now I have come to know I have till now total 16 and 19 matters.
Because this is a regarding electricity connection, so lordship may take it up as a top of the list, lordship.
Yes. List these matters on 31st at the top of the list.
Deeply.
And so, like,
Lordship, in respect of item number 46, 45, Lordship, I was in another court, Lordship has disposed of Lordship, so in non-appearance, Lordship, so kindly, so my.
Which one?
Item 45, Lordship.
What
Dispose
matter?
of Lordship.
Any
For-
IDC?
Yes, Lordship.
You did not appear.
I was in court 6, Lordship, but I was not thinking that Lordship orders will come first, Lordship.
It's given glaringly.
Yes, Lordship.
Then no case meet. ভৰাই দিব পাৰো। কোনটো? 40? 45?
Lordship.